So the apostille is required. It is the foreign. Who has refused? Have you applied for? Where is the application? Where is the refusal? There is no refusal. Given liberty to affirm the affidavit to the power of attorney without the apostille. What is the urgency? What is the urgency?
Petitioner is a private nursing home. From 2023 super specialty nursing home. From 2023, after obtaining the medical establishment license and professional fire license, from 2023, I have every representation to the fire authority that you come and inspect and give up. Suddenly, in November 2025, the health department issued a notification that within February 25, we have to the fire department must conduct a inquiry and give you the final license.
Correct.
Thereafter, I gave license. Only on 30th January 2026, the fire department gave me a 50-page recommendation saying that you have all interior safety, only you have to make additional staircases, you have to widen the pathway, like sort of 50 recommendations. Now the difficulty, we immediately wrote to the CMOE that the fire department has only given us on 30th January. We require at least 4 months time to complete those. We have issued the work order.
So what the court will do in this writ application?
The CMOE has issued a notification that within 25th of February, if the final fire license is not given, they will cancel my clinical establishment license. There are inpatient pilots, 40 inpatient.
So that's why who will take the risk if you're not having the fire license?
And department has stated that I have all everything. Only the additional, that is extending pathway. I have to widen the pathway. I have 4 extra staircases. They said that we have to make another one. These are the sort of recommendations. I can show it here. It's not that I do not have from 2023.
Leave granted, listed tomorrow as under.
May I have Lylord sign?
I leave, my lord. I have been delisted without a show cause notice, my lord, and barred from participating in future tenders.
What is the urgency? Let you file. Let the matter come.
Let the matter be taken up tomorrow or day after.
Why? What is the urgency?
Future tenders, my lord.
Future tender. Have you disclosed there are future tender day after tomorrow? Where is that? When is the tender?
My lord, my lord, it is pleaded, my lord. I'll bring the tender. The pleading is there, my lord.
What pleading?
That future tenders which I have been
future tender. So future tender not within a day or two. You file it, mention it, then we'll.
Lordship, may I have Lylord? Lord.
Yeah.
Sir, you have been blacklisted. Correct. With the future tender. So you have not disclosed any of the tender that yes, on 24 or 25 or 26, there is another tender is there. You will not be in a position to participate in that tender. Show me the document that there is another tender on 28 or 24 or 26.
Lord, that
as the case is made out in with the document. Pleading without the document.
Lordship, on 22nd of January, upon mentioning, Lordship was pleased to fix this matter on 19th of February, which is last Thursday, Lordship. The matter has not come, Lordship. I have served the other side, but the matter has not come. Lordship directed.
Not come means?
The matter has not come in the list.
Under which heading? What is urgency? What is the urgency?
Lordship, it was mentioned before, Lordship, the respondent authorities are not providing few documents to us which are required because those.
You check the diary. Either you not mention, you're not
Lordship, it was
not given the reason.
Lordship,
you mention, you're not given the reason.
Lordship fixed it on 19th only, Lordship.
So why?
I have served the other side as well, Lordship. On 22nd, I have mentioned the dates as well, Lordship.
Okay, give.
Praying for upgradation.
I already stated whoever want the upgradation, give the list. I will not hear any of the
My lord, may I be?
No. Whatever you want, you give to my court officer with the giving in writing. I will check in the evening.
My lord, extension of interim order.
Give, whatever it is.
রাজস্বী দত্তকে আসতে হচ্ছে আপনার মিস্টার
Under the same heading.
Not listed.
Unfortunately, my lord, is appearing under urgent motion 2 instead of urgent motion 1.
कल के करे, कल के टॉपिक करे.
Lord, item 71 of your lordship's list. Lord,
Today,
I got it, my lord, extended, my lord, Justice Mitro had, my lord, urgent determination, but Justice Mitro only extended for.
एक काम करो, वो सप्लीमेंट्री में लिस्ट कर दो. सप्लीमेंट्री 2 बजे कर दो. एक्सटेंशन ऑफ इंटरिम ऑर्डर.
Very great.
item
May be permitted under constant circumstances matter which has been disposed of by lordship. When matter was appearing in the combined living as item number 325. Somebody perhaps my lord mentioned your lordship was pleased to take it up on a particular date. Matter had appeared, my lord, on 18 February I don't know 20. Then, my lord, your lordship, we could not well be informed that the matter has already been in the list. And as a result, your lordship was pleased to pass an order. Of course, my lord, that order is not in my submission, will not create any difficulty. But the difficulty is, my lord, since the Municipal Corporation, my learned senior friend is there, but he had submitted all papers and documents to the already in court. Now his name is not appearing. As a result, my lord, he is, my lord, in some trouble before the authority, my lord, because not, my lord, representing at that particular time. That he mistaken, my lord, to the issue, my lord. Because of that, my lord, non-information of the appearance of the matter on 18th of February. The learned junior is in difficulty, my lord. That is the difficulty. Your lordship takes it as to be mentioned. Otherwise, my lord, I will not say anything about your. Because your lordship has ultimately disposed of the matter, directing the authorities to consider the
it's already disposed of. So what remains?
unless the name goes in, he cannot.
The difficulty is, my lord, of the learned junior friend, my lord, before the authority.
So you want the name is to be included?
Yes,
Only that, my lord.
Some
Authority
What's the material
to be
requirement?
mentioned for correction करके रख.
This is very urgent. We just went through and filed. It appeared yesterday as not item. Now it is item 71 urgent motion 1. But I have a visa to go. That under 10th passport. It's a settled law. So Lord, if my lord will give some priority to I cannot travel. It's an official tour. I have to go item 71.
When is going? When
Not
is
99 date of birth, I have to so if it comes up with site 71 WP 0. I understand your lordship is under too much of pressure. If sometimes could be given tomorrow, Lord.
कल रखो उसको within 5 minutes में.
Yes, I'm so grateful to your lordship.
What matters, the interim order is expiring today, your lordship.
इसको भी सप्लीमेंट्री में डाल दो 2 बजे. Today it is expiring.
Yes, your lordship.
सप्लीमेंट्री में डाल दो आज का.
I'm grateful.
Interim order, but it's expiring on Friday.
Friday means 27. Oh, 26 को रखो. So give all the mentioning. I will keep all these things.
This was a.
He made an application for the as a doctor, regular doctor. He submitted that certificate OBC A category. In spite of that, the authority treated him as a general caste. What have we lost? He appeared in the examination.
So you are a OBC. You are having the OBC.
APC A category.
हाँ.
I appeared in the written test examination. I got the 52.57 mark. Cut-off mark was 44.47. I was called for the interview. I appeared in the interview. But
So why this before this court?
because of the one of the notification done by the authority confirmed that because of the mismatch of the OBC of the birth certificate, the face face certificate lottery. I annex this.
No, these are recruitment. You go to the other court. No, this court is not having the determination regarding recruitment.
Group 9 matter lottery, group 9.
Group 9, you are asking for the appointment.
Asking for the consideration my birth certificate as I have submitted.
For the purpose of recruitment. So how the court can interfere in that? Go to the court which is having the determination of the recruitment process.
Hello, this was a leave matter on 17th of February. I sought leave. Your lordship was pleased to grant me leave. The matter was to come on 19th, my lord. Today is appearing at item number 69 of your lordship's list, my lord. This is the matter, my lord, where I am holding the lease for the last 30 years. It's a tourism department, West Bengal tourism department's lease given to me, my lord. Running the hotel on 13th of February, they write me a letter. 10 days time you vacate, you hand over keys and you get out. So now the 10 days expired on yesterday, my lord, 23rd, my lord. I'm running every second. I'm running a risk of losing the hotel, my lord. I've spent more than 10 crores in building the hotel, three floor structures, new sanction plan, everything, my lord. Agreement is almost from 2000s, my lord. I could only start operations in 2015, my lord. Sufficient, huge investments made. Well, item number 69 today, my lord.
What can be done? All are urgent matters. Day after tomorrow, within 5 matters. Day after tomorrow, within 5 matters.
Upon notice, I'm so grateful, my lord.
The wetland matters, your lordship.
Huh?
My lord, the wetland matters, your lordship was pleased to fix the matter on 19th and 20th at 2 p.m. under the heading specially fixed matter for hearing, my lord. The matter was not taken up on those days, my lord. Now the matter is appearing today as item number 120. My humble submission, my lord, your lordship kindly fix any date under the heading specially fixed matter. Any date, my lord. And my lord, on 20th, my lord, the interim order has already expired in respect of item number 125. 126, my lord, the interim order will expire on 27.
So what do you want?
My lord, any date for hearing, my lord.
Date, you will not get the date specific before 20 April.
20th?
After 20th April, you will get the date. Now I will cancel all the matters, hearing matters. I will only take the adjourned motions.
Lordship, kindly-
Urgent motions. I will not hear any of the as per your choice. If you want the hearing matter is to be taken, then you less mention. I will take the hearing matter. You keep on mentioning the matter, then I will pass it. Today I will issue the notification. No hearing matter will be taken before vacation.
Lordship, kindly fix it under.
See, 2 days I was not there. 120 matters has come as urgent motion, and again you are mentioning the matters from the list itself,
My lord,
where the court will adjust you.
My lord, the matter was fixed under the heading specially fixed. So your lordship kindly fix after 20th, my lord. But interim order, my lord, your lordship kindly extend.
उसको एक काम करो, कल
Item number-
कल 2B मेंशन में रखो उसका extension of interim order and fixing a date for hearing करके.
My lord,
Inform the other side.
my lord, one
If the other side will not come, then I will not fix.
My lord, may I have lordship kind leave for a matter? My lord, the petitioner is suffering from kidney disorder in the last stage, 5th stage of chronic kidney disorder, and he found a friend of the petitioner's elder brother. They both applied under the Transplant of Human Organ and Tissue Act 1994, and they both applied, but the authority refused their application. And he is 34 years of age. Both kidneys are damaging, my lord.
What is the ground for refusal?
Without any reason, they did not give any reason, and verbally they are refusing.
When it was refused?
It 11 November.
So, what is the urgency after 4 months?
My lord, he is only 34 years of age.
Maybe 11 November it was rejected. Now we are on February end. Correct.
My lord,
Just for the last 5 months. Now all of a sudden you got the urgency.
My lord, may I permit? My lord,
Yes.
there is a do or die situation, my lord.
Maybe so
Day
5
by
months.
day-
What you are doing?
Day by day, my lord, the patient situation is deteriorated.
What you
my
have
lord,
done from 11 November to February?
But we try to gather the documents and others. My
What
lord, that's the
document?
reason we need to give the proper documents to get the my lord kidney transplantation. That the reason, my lord.
उसको
Affidavit and all things we have to gather that.
20 तारीख को रखो within 5-10 matters.
Kindly, my lord, grant.
My lord, may I?
With 2020
My lord.
within 10 matters. 20 नहीं 27.
Grateful, grateful, my lord.
Apologize for troubling your lordship. Item number 70 of law, my lord. My lord, the urgency is that the technical bid will open on Friday. My lord, the specified time period for.
You all are not understanding the English language. Can I go to the tuition center? I can learn the Bengali language. Since morning, I'm telling whatever the urgency, give to my court officer. You're wasting the time. 15 minutes already wasted.
My lord, one
Whatever the
restoration,
urgency, give to my court officer.
my lord, one restoration application of a police.
Then again,
My lord, for inclusion, my lord.
just call the list.
Milord, may I only,
There's an urgent tender matter, my lord, which is opening on the 6th, my lord. 6th is the last date, my lord, of the tender. Playing that it will be taken. There's an urgent tender matter, my lord. It's the tender will be closed on 6th, my lord. I've been disqualified on reasons, my lord, which are entirely extraneous.
Item number 1. Item number 1.
I appeared for the
Milord,
Your lordship kindly permits one mentioning on the virtual, please.
Yes.
There's a tender which will close on the 6th, my lord, a tender floated by the Airports Authority of India. I'm challenging the terms, my lord. Kerala High Court has already given me an injunction in a tender floated for the Kerala unit, my lord. This is for the Calcutta unit, identical tender conditions, my lord. The tender is closing on the 6th, please, my lord. That is the urgency.
What is the date of the opening of tender?
The opening was 25th January. Then the pre-bid clarifications were going on. So the pre-bid clarification was rejected last week, my lord. And that is why we approached first the Kerala High Court, and then we filed before your lordship.
Whether your matter is listed here in the
No, my lord, it is a new filing, my lord.
file
It's a
it.
new filing. It's not listed.
16th of February.
Huh?
It was filed on 16th of February.
Milord,
Where is the number?
Your lordship 3830 of 2020.
Give the mention, give the all the urgency. I will see to that. Yes, call the
Milord, before Milord, Lordship takes up the matter, Milord, may I only mention this urgency, Milord? This matter is fixed today at 2 o'clock. Your Lordship has been pleased to fix this matter, Milord, at 2 o'clock. Milord, I am led by Mr. Abhishek Mitro, Milord, because of the bereavement in his family, Milord. Milord, he is in difficulty. So may I only pray, Milord, any day after 5th, Milord, if it is retained in the list, because he's my leader, I'm mentioning this. We have done so, Milord, upon notice on all the parties, Milord.
I don't stand in the way whenever your lordship keeps the matter.
Okay, 2 p.m. I will, when the matter is called, I will adjourn the matter accordingly.
Milord, I am very, very deeply appreciated.
Yes, so is
Very
number-
deeply appreciated.
Your lordship, I have filed one application under.
I
Yes.
appear for the petitioner, your lordship. This is my writ petition challenging the arbitrary and illegal demands.
Huh?
This is my writ petition
Hmm.
challenging the arbitrary and illegal demands of the responding authorities, that is the railway authorities, on account of engine and road charges.
Hmm.
Your lordship, the petitioner had set up a siding
Hmm.
in terms of the contract with West Bengal Development Power Corporation Limited at Sagadigi Thermal Plant, Murshidabad.
Hmm.
Your lordships, during this period, fly ash was generated. And since fly ash is an environmental hazard, the petitioner used to pack these fly ashes in bags and
Why it is mentioned?
Your
Why
lordship,
to be mentioned?
for directions for affidavit, your lordship.
Directions for affidavit.
Yes,
Who
Your
is for the other side?
Lordships,
My lord, I am appearing for Union of India, my lord, for railways.
Who is the person? Who is the authority to release the amount?
the
Answering respondent.
railway authorities, your
Huh?
lordship. Railway authorities.
Railway, you are appearing for the railway.
Yes, my lord. In this matter, my lord, I am also appearing for railways. Affidavit is, my lord, needed, my lord. This is a very long matter, my lord, to explain.
It is to be mentioned only for the purpose of direction for filing affidavits. The respondents are directed to file affidavit in opposition within 3 weeks.
My lord,
Within
my
3
lord,
weeks,
my lord.
reply if any have to be
Within
made.
1 year, 2 weeks.
Within a week.
Within a week, your lordship.
Within a week thereafter, full stop. Let the matter appear on
April. I'm praying if the matter could be listed in the month list of April, your lordship.
appear on 8th April 2026 under the heading adjourn motion.
Grateful, your lordship.
Yes, next.
Deeply obliged, my lord.
My lord, I am for the petitioner, my lord. This is my application for restoration, my lord. I have served, my lord, copy of the restoration application upon Mrs. Suma Raichaudhuri, my lord. And, my lord, she requested me. She is not present, my lord. Her junior is here.
Mrs. Soma Raichaudhuri is appearing for the LICI lordship. She is out of station. Lordship. Mrs. Soma Raichaudhuri is appearing for the LICI. She is out of station, lordship.
When this matter was dismissed?
Dismissed on 29th March.
29 March 2022. 2022.
I filed 31st March.
Oh, you
within
filed
1 day.
31st March. Till date it is pending.
Yes, but since then it is pending.
For the last 3 years it is pending only for the
It
restoration.
was moving, my file was missed.
What is the writ application?
Read application, my lord.
What you have paid for in the writ application?
Read application, my lord. The only for the husband of the petitioner expired, my lord. My lord, the LIC policy, having LIC policy. My lord, they are claiming that LIC authority that one default was done, my lord, during the lifetime. That is why they are not granting, my lord, the benefit of the insurance. My opposition reply has already been done. It is for hearing, my lord. Let it, my lord, kindly restore the matter and fix the hearing, my lord. My lord,
Restoration you have taken 3 years.
no, my
Then
lord.
you will take the hearing for further 3 years.
Lord,
And you persons will write to the authorities. Court is not taking the matter for the last 10 years. The matter is pending
No,
before
my
the
lord, kindly see. My lord, I filed within 1 day.
You will bring the authority. I will dispose of your writ application. Otherwise, I will not take your restoration application. The matter is listed as under the heading application. The petitioner has filed an application being Can 1 of 2022, praying for recalling of the order passed by this court on 29th of March 2022, wherein this court has dismissed the writ application for default on the ground of non-appearance of the party when the matter is called. Non-appearance of the petitioner. Full stop. The counsel for the petitioner submit that on 29th of March 2022, the matter was dismissed for default. Immediately on 31st of March 2022, the petitioner has filed the present application for restoration. This court found that for the last more than 3 years, the matter is pending for hearing of the restoration application. Full stop. In the writ application, the petitioner has challenged the reason order dated 25th of October 2011. According, this court is of the view that the writ application, the Can application along with the writ is to be taken up for hearing on the next date fixed. It is made clear that on the date fixed, if the petitioner failed to appear before this court, the matter will be taken up for hearing in accordance with law. The petitioner is directed to inform the next date of hearing to the respondents. Both the parties both the parties are directed to come ready. Please the matter on 18th of March 2026 under the same heading, under the heading urgent motion.
18 months.
No, same heading, application query.
Hearing, man.
Application. Yes, next.
My lord, I am for the petitioner. There are two Can. One is section 5 and another is recalling of the order dated 1st May 2024.
What is the order?
Order is my restoration has been dismissed.
Your restoration has been dismissed.
Yes, that is the I am the most unfortunate person maybe. The reason for holding the dismissal of the restoration is that repeatedly I have not appeared. Although my learned advocate under court is
it will go to the same judge. How this court will hear the matter? Your application is dismissed as unmarried.
Presently, my lord is having the residuary jurisdiction.
Residuary, but you are asking for the recalling of the order dated 1st May 2024,
Yes,
wherein your restoration application was dismissed. So this is a recalling of the order and the judge is available. So I am releasing the matter.
May I?
The petitioner has filed the present application being Can 4 of 2025, praying for recalling of the order dated 1st May 2024, wherein this court, the coordinate bench of this court has dismissed the Can 1 of 2024, wherein the petitioner has prayed for recalling of the order dated 11 March 2024, by which this court has dismissed the writ application for default. This court finds that the petitioner intend to recall the order dated 5th May 2024 passed by her ladyship, Rai Chattopadhyay J. It is available. J. Thus, the matter is released from the list of this court with the liberty to the petitioner to mention before her ladyship for hearing of the present application.
I am grateful.
Next.
Lord, I appear for the petitioner, my lord, in this matter.
Yes.
This was the matter with regard to the issue of, my lord, stamping on a deed of assignment of copyright.
Yes.
Lordship, after hearing me, my lord, was hearing the state when a question came whether, my lord, my lord, registered copyrights were, my lord, there.
For the other side.
My lord, the state all along, my lord, they were represented. Every time, my lord, they came, my lord, Lordship, in fact, permitted me to put a supplementary which I have filed in court. And I was also required to serve them, my lord. I have served them also. This is the affidavit of service. So they were supposed to, my lord, now respond to that. Because the only issue, my lord, principal issue was whether, my lord, this exercise of or assumption of jurisdiction under section 47 of the Stamp Act was correct or not. Because if there is no undervaluation, you cannot invoke section 47 and 47A. And if there is, my lord, so the first question was jurisdictional question. The second question, Lordship felt that let me see the registered copyright. So Lordship permitted me to put in that and file it, disclose it in the form of a supplementary, which I did. So if the registered copyrights are also there, there was no question of, my lord, being, my lord, penalized with this order.
But nobody is here.
This is the second time they are not here, but
Affidavit of service filed by the petitioner be kept with the record. As none appears on behalf of the respondents, for the interest of justice, the case is adjourned. Let the matter appear on 5th March 6th March 2026. Full stop. And the petition directed to inform the next date of hearing to the respondents. It is made clear that on the date fixed, if the respondents will not appear, the matter will be taken up.
I'm very grateful, my lord. Very grateful.
Under the same heading, huh?
My lord, in item number 3, I am for
I see affidavit of service also.
I am for the respondent. I was in other court.
Yes, I have released because this is just
My name at least.
Give.
Leave your question.
Well.
Hey, 13.
The matter was listed on 7th November 2025. None appears on behalf of the parties. According case was adjourned till 20th November 2025. On 21st of November 2025, again the matter was taken up for hearing. But again, none appears on behalf of either of the parties. According case was adjourned till 28th of November 2025. With the rider that on the date fixed, if none appears on behalf of either of the parties, appropriate order will be passed. Today again, when the matter is taken up for hearing, none appears on behalf of either of the parties, no accommodation is sought for. Full stop. This court find that this full stop. The petitioner has filed the present criminal revisal application against the judgment and order passed by the London Special Court, Tamluk, Purva, Medinipur, dated 31st of July 2008. In Medinipur case number TR2 of 1992, arising out of Durgachak Police Station, case number 10 of 10, dated 27th of August 2004, corresponding to GR case number 746 of 84 under section 409/466/468/420 of the IPC. The learned special judge, on completion of the trial, come to the conclusion that the prosecution failed to prove the case, and accordingly the learned judge found not guilty against the opposite party, found not guilty for the offense punishable under section 409, 466, 468, 420 of the IPC, and accordingly acquitted the accused persons from the said case. Accused karo, police. This court find that the prosecution has examined altogether 11 witnesses, and 13 documents have been exhibited. But when the learned judge has analyzed the evidence and the documents, has come to the conclusion that the prosecution has failed to prove the case, and accordingly the learned judge has acquitted the accused. This court also considered the judgment and the documents available on record. It is found that during the cross-examination of PW1, he has stated that the documents seized by the investigating officer do not relate to the tenure of the accused in the office of the Haldia Development Authority, and he has not go through the said document before producing to the IO when the said document was seized. Full stop. The PW2 also did not said anything against the accused. Full stop. PW8 stated that he used to deposit rent at cash counter of the office of the Haldia Development Authority, but he failed to recognize the accused. The PW8 has also turned hostile. PW9 also failed to recognize the accused who was present on dock, and he has deposed that some documents of their company has been deposited in the office of the Haldia Development Authority, but he has not stated anything against the accused. Consider the judgment and the material evidence on record. This court did not find any merit in the present revisional application. Full stop. Accordingly, CRR number 1 dismissed. Next.
This matter, my lord, I am appearing on behalf of the respondent, State Bank of India, my lord. But I have also served a mail to my learned friend, my lord. Because I have not received any copy. That is my instruction, my lord. I have not received any copy.
Not received the writ petition, copy of the.
That is my instruction, my lord.
Long before, my lord, recently notice has been given that it is ordinarily mentioned before lordship. At that point of time, no service has been made. My lord, everybody has been served, my lord.
It is
I have
served.
received the notice.
He may not have.
I have received the notice, but not the writ petition, my lord.
This is the notice, but not the writ petition.
This notice is served.
I have also sent a mail to my learned friend, my lord. I have also sent a mail to my learned
It
friend.
was November 25. November 25 it was served.
My lord, maybe I am not disputing that. My
September
lord.
5, November notice.
But I will only request my learned friend to serve a copy.
Give the copy. Give one
And
copy.
if necessary, I will pay the cost for it. But that
Yes.
is my instruction.
What is the matter?
My lord, the petitioner is, my lord, the Homeopathy Medical College.
What is your prayer? I will.
My lord, the bank authority has stopped, my lord, the operation of my bank accounts, and for that, my lord, salary of the staff, my lord,
All the things are stopped.
everything is.
Okay, you saw the copy. I am fixing next week.
My lord, next week I have personal difficulty, can be done the second week of March.
So 10th of March. Huh?
I am Dr. Chinmoy Jha.
Ah.
I have stopped the bank account.
Hmm.
I have wrote the letter to the bank, but I am not party here.
You're not the party.
No, they are awaiting
My lord, according to the law, according to the act, I have annexed that act, my lord. The principal and one of the nominated LMC member is, my lord, the bank operating.
No, whether any complaint has, any case has been initiated against you.
No, nothing. No case.
Only you have made a complaint to the bank authority.
Stating that he is the original authority or signatory, he wrote letters to several banks. One of bank is mine, that is Vidyasagar Central Cooperative Bank. Considering that there are disputes with regard to management and with regard to genuine valid signatory who are the secretaries of this college and the society.
Okay, you do one thing. You made a party. Give the copy. What is your good name?
I am Dr. Chinmoy Jha.
What post you are holding?
I am in that college. I am secretary of Kharagpur Homeopathic Medical Education Society.
But it is society, not the
Society run
college, and I am the secretary of the society.
And society has nothing.
And you are working in the same college.
College, madam, not the society.
Not a society. So how you are connected? So how you are connected with?
But college is under the society.
College is under the
Banking
society.
authority is.
Okay, let. What is your good name?
I am Dr. Chinmoy Jha.
So and so appearing in person, and submit that on his prayer, on his request, the bank authorities have stopped the operation of the bank account of the
Several banks.
bank accounts of the petitioner. Petitions. He submits that he is the necessary party, but the petition has not made him as a party in the present date application. Consider the submission made by the so and so appear in person, comma. The petition is directed to furnish that address. Petition directed to add so and so as added respondent number as 10 in course of the day, and to serve the copy of the writ application to the added respondent by 26th of February 2026. List the matter on 10th of March 2026 under the same heading.
Great watch.
Next.
We can study.
Right. Right, number 14, I have observed the petitioner.
Yes.
Pursuant to your lordship's last order, my lord, the commission has filed a report in form of an affidavit, my lord, disclosing all the relevant documents that they were filing on at the time of hearing. In view of the fact, my lord, that they have not filed any affidavit. Just briefly indicate, you know, this pertains to, my lord, a finding of the West Bengal Regulatory Commission, whereby, my lord, the clinical is commissioned.
Huh? Yes. Yes, I remember. So you want to file an exception to these documents? If you want to file exception, you file it. Because it's a new document they have introduced. You have not filed the affidavit, you have filed the report only.
Yes, my lord, I have filed the report. My lord, he is the complaint.
So if you want to take exception, you take exception. Otherwise, I will say you will not take exception. I will fix the date for hearing.
Your lordship,
It can be heard today itself.
Your lordship, I am appearing for the respondent who is the suffering. I am the complainant, your lordship. Your lordship, the direction was to provide this honorable court all the pleadings which has been filed before the lower court below.
or before the tribunal. So this is not a document which has been, this order has not been passed ex parte. So today they cannot stand and say ki we are not aware of any other document.
The observation of your lordship, my lord, since the commission did not file an affidavit, your lordship can commission to disclose all the documents.
Whatever the document.
Let a copy be served upon us as well. A report.
The respondent number 1 has filed affidavit by disclosing certain documents. Full stop. The counsel for the petitioner pressed for time to take exception to the documents filed by the respondent number 1. That exception is filed by 1 week. A reply, if any, there to be filed within a week thereafter. List the matter on 19th March. The interim order is extended till 23rd of March 2026 or until further order.
Your lordship has substantially heard this matter. Your lordship has to fix a time on a.
Time, then you will go to April. I have no problem. But if after 20th April, if you're ready to go to 20th April, I will give that. Or you want to take the chance in the urgent motion, you come up with the urgent.
No.
There is no problem.
Let's fix it for the. Fix it.
Fix the time.
We will do it.
So let the matter. देखो अप्रैल में कब है? 20 तारीख के बाद क्या डेट पड़ता है? 20th April at 2 p.m. as especially fixed matter. Interim order is extended
till 20th April.
Till 22nd of April 2026. Yes, next.
I'm appearing for the petitioner.
May please, I appear for the respondents in this matter. I'm sorry for appearing virtually. I just have one request. I'm led by Mr. Shudipto Shorkar. He's just on his legs. I was just praying. I know your lordship was a fixed matter at 12 today. If it can be tomorrow, because your lordships had kept it on top 5 matters on Friday. But since the I was just praying tomorrow, if your lordships can keep it, we can all come and assist your lordships physically. I just think 1 day's accommodation. Till tomorrow. I'm led by Mr. Sudipto Shorkar. He's just on his legs.
Understood your instruction. Lord, I would have had no difficulty tomorrow, but I may not be there tomorrow. That's the only difficulty. This matter, this urgency is because, Lord,
it will be burdensome for me. Let him be there.
Lord, urgency, I'll just tell my Lord in 1 minute. Then my Lord can, whatever my Lord decides. But there's a company, my Lord, which is involved, my Lord, insolvency. Lord, there's a resolution plan, my Lord, which has been approved. Now, my Lord, under the incorporation rules, my Lord, it requires that, my Lord, if an appeal is pending, then, my Lord, the registrar office, my Lord, can't be shifted. The registrar office, my Lord, was within, my Lord, West Bengal. Now, my Lord, in spite of the pendency of the appeal, my Lord, the registrar office now has been sought to be shifted. So, my Lord, we are opposing that. We are one of the creditors, my Lord, of the company, my Lord, which is, my Lord, in insolvency. And, my Lord, we also preferred, my Lord, appeals, my Lord, before the NCLT, my Lord, the appellate tribunal, which is, my Lord, pending.
How many petitions? 2.
One.
Two
petitioners.
So you are the?
Lord, I am one of the creditors. No, he's the director. Petition. Lord, I am
for the promoters of the company.
I am one of the creditors, Lord, of the company.
Yes.
So, Lord, I am on a question of law. Lord, we find, Lord, the regional director, somehow, Lord, ignoring, Lord, the company's rules, which is, Lord, specifically incorporated, Lord, for the purpose of dealing with an insolvency and bankruptcy court situation, has said, no, IBC overrides, and therefore I am permitting, not noticing, Lord, that the amendment itself provides, it's a post-amendment, post-Lord IBC, and provides that, Lord, if there's an appeal, you can't shift it. So on the face of it, I don't know, Lord, how the regional director has, Lord, that such adjudicatory powers, Lord, then say, no, I'm permitting transfer. And particularly on the previous occasion, he has himself, Lord, said that because appeal is pending, I'm not going to allow this transfer. Lord, this is where we stand. So, Lord, I don't want them, Lord, to take any further steps, Lord, as of today. That's, Lord, all.
I want to
I am just saying, tomorrow.
Lordship, it's a 4th February.
I'm sorry, Mr. Shah is senior to me. It's a 4th February order. Malaj, may I say
Malaj, I
this?
just
Malaj,
want-
I am not, Malaj, we were there before your lordship, Malaj, unfortunately.
Tomorrow you have difficulty, then when you
Just tomorrow morning, Malaj, tomorrow morning.
Malad, tomorrow and day after, I'm not the Friday then, Malad. Tomorrow I may be there, but I'm not very sure, Malad. That's the only difficulty.
Friday.
Friday top matter, Malaj, your lordship's first matter,
Wait
your
till
lordship
day
thinks,
after
Malaj, we can
tomorrow,
come and do it.
Subject to the convenience of my friends. wait
Mr.
till
Shah,
day
Mr.
after tomorrow.
Mr. Shah, you are appearing for?
My lord, I am for the promoters of the company, my lord. I am the most affected person. My appeals are pending before the Honorable NCLAT.
Malaj, Malaj,
Okay.
Malaj, these promoters, Malaj, the creditors, everyone.
For the prayer made by the counsel for the respondents, let the matter appear on 27th. 7th.
Malad, kindly, Malad, kindly keep it tomorrow only, Malad. Kindly keep it tomorrow. I think, Malad,
Kindly
because
keeps
of,
it
Malad, the
tomorrow,
urgency,
Malaj. Very well, Malaj. Tomorrow. Tomorrow. Very well, Malaj.
Very grateful.
Lordship, will it be there in top 5 or your Lordship's convenience?
Let's just requesting, considering Malaj, the urgency.
I'm led by
Urgency.
Dipto Sarkar, your Lordship. He's
Malaj, no, Malaj, I just.
Tomorrow at the top, under the urgent motion.
At the top.
Grateful.
I'm so grateful. So grateful, Malaj. So deeply obliged for the indulgence, Malaj. And apologies for appearing virtually once again, Malaj. I'm so sorry.
Come tomorrow?
Yes.
Tomorrow, Malaj.
Come, you are the. Yes, next.
My lord, I am appealing. My lord, I am appealing.
Huh?
From the 16 Lordship, I am led by Mr. Jishnu Chaudhary in this matter. That he is out of.
Who is for the petitioner? Let me. Yes, what is the matter about?
One of the matter is extremely urgent in view of the fact that an order was already passed by the district forum, went up to the NCDRC. Thereafter, we filed this writ petition before the Honorable High Court at Calcutta in view of the Supreme Court's decision. And thereafter, it was admitted and there was an order that the execution case might continue, but it will not be disposed of without the leave of the court.
What your challenge? Your challenge?
I've challenged the orders of the NCDRC as well as the district forum.
District forum.
Yes, because
whether it is maintainable.
Yes, I'll come.
By which order?
I'll come to the decision.
Don't think so.
It is maintainable, my lord, in view of 2 decisions of the Supreme Court. I had already satisfied. Just give me a moment. I'm sorry, my lord.
226 or 227?
226 also and 227. I'll just come to it. We'll come to it.
Which order you are relying upon?
My lord, this is Universal Sampo General Insurance. I satisfied the court on the last occasion. Sorry, my lord, I'll just take it out. Kindly takes it up, my lord. Paragraphs 24, 37. 37 is more important. It comes straight away to the point. Paragraph 37. Now kindly comes to 38, my lord. Paragraph 38. In the aforesaid view of the matter, we have reached to the conclusion that we should not adjudicate this petition on merits. We must ask the petitioner here to go before the jurisdictional High Court, either by way of a writ petition, application on Article 226 of the Constitution, or by invoking the supervisory jurisdiction of the jurisdictional High Court under Article 227 of the Constitution of India.
You are having the judgment of Ibrat Faizan?
No.
Ibrat
Yes, I have the judgment. I have the judgment.
2023 volume 11.
Yes, I'll come to it. Ibrat Faizan. But it is in live laws.
Lord, I have a Supreme Court if Lordship wants to.
My lord,
Mr.
paragraph
Supreme Court.
45, the last quote, where it has been held that in view of L. Chandrakumar's decision, it should go before the jurisdictional courts under Article 226 and 227 of the Constitution of India. And my lord,
Kindly come to the paragraph 23. Paragraph 23, Ibrat Fazan.
yes. Where's paragraph 20?
Got it?
My one doesn't have a paragraph 23.
You're
Because I've given live laws.
I have acted opinion, Lordship. Opinion. No.
It says about 20.
14.1. Your judgment.
Yes.
14.1.
Yes. The scope and ambit of jurisdiction under 227 of the Constitution has been explained by this court in Estola Rubber versus Das, which has been consistently followed by this court. See the recent judgment and so on. So therefore, while exercising the power under 227 of the Constitution, the High Court has to act within the parameters to exercise the power under Article 227 of the Constitution. It goes without saying that while considering the grant of interim stay in a writ petition under 227 of the Constitution, the High Court has to bear in mind limited jurisdiction of superintendents under 227 of the Constitution. Therefore, while granting an interim stay relief in a writ petition under Article 227 of the Constitution against any order passed by the National Commission, the same shall always be subject to the rigors passed to be exercised under Article 227 of the Constitution. This is one part. And taking into consideration this, the previous judgment which I have shown to your
Yes,
lordship.
24, but this has not been considered.
Are
I deferring because because how 227 226 will lie, one condition.
Yes.
Before the consumers forum, the dispute between two parties.
Correct.
Private parties.
Yes.
And private parties, whatever the award is passed, appeal, where is the stay? State is not a party. If the state is not a party, how the 226 will lie?
That's exactly the question which fell for consideration when the matter was originally taken up and it was actually admitted. But since the High Court has already, Supreme Court has said that 226 is also applicable.
226 or 227?
Then
That's why the 226 will lie if the state is party, if the statute.
That has not been clarified because in this kind of.
I will clarify that. Because one matter is already going on hearing from other matter. That's why I'm asking you.
That will not debar your lordship from converting the same into 227 if this so comments.
Yeah. 227 cannot be 226 cannot be.
But
liberty you can file it.
No, that will be a massive problem because I tell you, lordship, it has been admitted on the ground that this writ is maintainable. Now,
where is the maintainable?
The order is already there.
This one, Supreme Court judgment.
No. This honorable court.
Ordinary
Earlier, yes.
Where is that?
Single bench said that.
Where is that? Where is that?
The order itself.
As far as I can recall, that petition was left open. Lordship,
It was not left open. We had even.
Where is that? Where is the order?
Justice Shampa Sharka's order.
Justice Sharka's order.
Required
Well,
adjudication.
Yes.
Pending for disposal. There is nothing.
There is an order that it should go on, admitted, naturally. And there also, Justice Shampa Sharka said that in my view, it should be basically under 227, not 226. But since the Supreme Court has said that 227 and 227 both lies, so I have no other way than to say that this is not maintainable. This is maintainable.
Okay, come ready when you will come. Ready?
My lord, that is, my lord, I'm led by Mr. Chaudhary in this matter, lordship. He has requested if it can be kept tomorrow or my lord.
The problem right now that we are facing is, after that particular order, we were made to pay 15 lakhs. They were all quorum non-judice matters. It's a single bench order has been passed. These are quorum non-judice matters. It will be struck off within a moment by your lordship. Once gone into and the decisions of the High Court and Supreme Court is pat on the face. Only thing which requires is whether this is quorum non-judice or it's a good order. And that point we raised before the National Forum, it did not consider that point. So,
No,
limited.
quorum non-juris is also there. It is not a quorum non-juris. How single member has passed an order?
Yes, yes.
Extend to.
Yes.
I have seen it. I have seen it. I'll satisfy lordship on the issue. Whether a single member, not even the chairman, a single member,
Sorry.
it is there. The Supreme Court is pat on the point. A single member cannot pass an order. And in view of the,
Coordinate bench order is there. Our coordinate bench order.
Coordinate bench, but the Supreme Court's order is also there.
So which order?
Yes, I'll come to it. Barkar?
Okay, you're not ready. So when you will come?
But there is
When your senior will be available?
my lord,
The point of law only.
my lord, tomorrow lordship or my lord after.
Tomorrow all matter.
My lord after 6th lordship if it is. If it's
So
suitable.
your execution is stayed, already stayed.
There is no stay. I have been now told that you appear and pay another 5 lakhs.
My lord, may I say one thing, lordship?
The tribunal has given
Pressing
that
on
order. Kindly
urgency, my lord, why I'm saying that.
Who are you?
My lord, I am the complainant before the proceedings. This matter was filed in 2024. My lord, there have been orders. If lordship recalls, my lord, I had come and mentioned this matter before your lordship being a respondent.
Correct.
And my lord, they have not taken any steps in the last 2 years. They have in fact filed another writ petition which was released by a coordinate bench. They filed a contempt which was dismissed. They did not proceed with this matter until and unless, my lord, I requested the executing court, my lord, to proceed. Even though there was no stay, now, my lord, at this juncture, the executing court has told them that there is an outstanding of 17 lakhs. You at least pay 5 lakhs. This happened, my lord, on this day. I've got nothing.
If you want to proceed with the matter, then I will take the matter today itself.
My
If you will not proceed the execution
Lord,
proceeding, then I will take the matter as per your
my lord,
convenience.
lordship kindly fixes it tomorrow or my lord any
Not
date.
tomorrow.
Lord, file fixes a date for final hearing. My lord. I am also praying for that, my lord.
So you not to proceed with the execution. Not to
One
proceed with the
thing,
execution
kindly
proceeding. There are two law points with regard to 226 or 227, whether the quorum non-judice.
Tomorrow itself, lordship. I am praying for a
Tomorrow
final
I will
hearing.
not. Court has to see the
My lord,
our own
Thursday,
diary.
my lord, in that case.
My lord, kindly seize the order.
Studied, I am taking the matter today itself.
My lord, Thursday, my lord, he has
Before
requested lordship.
this month, it is not possible. Kindly see my adjournment.
My lord, in that case, lordship, can a date be fixed, my lord, so that
Then
my lord,
April,
lord, April will be.
April 21st of April, I will take fix the date at 2 p.m.
My lord, that.
And I will pass an order not to proceed with the execution case.
There's that order, my lord. Last day's order, my lord. They have been directly appear before the court with 5 lakhs, at least.
Where is the order? I don't find where is the order.
This is the order given 2-page order right now.
Adjudication condemn, which is
Yesterday,
pending
they have
disposal.
supplied me with more documents. Lord, I have to peruse all
Where
of
is the
this
interim
as well,
order?
lordship.
There is no interim order.
There is an interim order.
Why so?
I'll come to it. Order to They shall not be other. Supplement.
So which order? By which order?
I'll come to it.
Execution application shall not be disposed of.
Yes.
Before disposal of the writ application. But
Yes.
proceeding may continue.
Yes.
So what can be done?
So, my lord, it has to be stayed. It must not be contention.
Coordinate benches pass an order. How the court can modify this?
In view of the fact that this kind of orders are being passed, so every
August 2024, this order was passed. Then you not file an application on modification or early hearing.
But at the same time, I had made several applications that it was not the
Counsel for the respondents press for time according cases adjourned. Let the matter appear on 11th of March 2026 under the same heading.
Grateful, lordship.
well, the execution will go on well in the meantime.
What can you have obtained the order? This court has not passed an order to go. You have obtained the same order.
Let me file the supplementary affidavit and
I've received a
I have filed an application.
What you are filing?
All the documents which were
Supplementary
there.
affidavit filed by the petition be kept with the record.
At
It
the
is
same-
directed to serve the copy to the.
At the same time, there is a CAN application which is CAN 1. So logically takes it up.
For what?
That is for stay of this particular operation.
I have not received CAN 1.
CAN 1 I have given to them. I've served.
Next.
In the meantime, the proceeding continues.
Coordinate bench already passed an order. How this court can now modify without the application?
We have filed another application
Where
for
is the application?
CAN 1, your lordship sees.
Then I have
CAN
to
1.
file an-
Where is the can give the what is the application? What is the can one?
They have been proceeding in this matter, so stay of the execution proceeding. Previously also they wanted 15 lakhs, they've taken out 15 lakhs.
Where is the prayer for modification of
Not modification for stay, my lord. For stay.
Sir, you being the senior person, when the coordinate bench has passed one order. Now you want that the stay, the court at that, not to dispose of the execution proceeding, but it may continue.
Yes.
You have not challenged that order. Correct.
But
Not
the
challenged
modus,
that order.
the modus,
That
I
is-
understand
that
what
is
is falling from your
2024.
lordship.
Now you filed an application for stay of the proceeding.
Yes.
It has already dealt with.
In the
You have not filed an application for modification of that
but in the
order.
changed circumstances, can I not file this application?
You can file, but without the modification, can this court pass an order? Without the modification of the earlier order?
That is again a point, Madam.
Where is the application? Where is the prayer for the modification?
It's not a modification order, it's for further interim order, Madam.
Further-
Further interim order in this matter.
Yes, next, call.
Follow now.
Lordship, I beg to appear on behalf of the petitioner. Lordship, kindly recall, this is relating to my lord termination of an employee of a teacher under Vishwabharati University. Lordship was kind enough to hear me.
It's a direction.
My lord, not a written direction. Lordship was kind enough to direct them to look into certain papers and documents and to come back and to reply.
Yes,
There is
after going through, my lord, I feel, my lord, there are at least 3 papers, my lord, which ought to have been brought on record, because my lord, after the High Court has passed the order on 24th of August 2021, that lordship will find at page 58, where my lord, he was granted liberty to make a fresh representation. My lord, he made a representation on 10th of September 2021. Now, my lord, that is not on record. Secondly, my lord, certain queries were, after receiving her representation, the university raised certain queries to her. She has given a reply, that is at page 67, my lord, of the writ petition.
Yes.
Page 67 is only the covering email. The annexure to this, my lord, this is actually a 230-page document. My lord, this representation, my lord, contains all her submissions before the inquiry authority. And my lord, he was also issued a warning in 2016 regarding, my lord, her conduct in the basically her negligence towards the duty in the project. My lord, that is also not on record. My lord, these documents, my lord, I think, my lord, is required because, my lord, this issue which has now cropped up before the lordship, that earlier she was terminated by a one-liner stating that her conduct in the referring to her conduct in the project. Now, my lord, here now the fresh termination order, my lord, this also relates to her conduct in the project itself, but deals into details of her negligent act in the project. Now, my lord, negligence, mere negligence is not a misconduct. That is what the Supreme Court has explained what misconduct is. Now,
So if the negligence is not a misconduct, can you terminate? If there is no misconduct of the government servant of
Negligence-
the employee, can you terminate?
my lord, she was not a permanent employee.
Maybe.
My lord, if she is
That's why I'm telling, if she is not a permanent employee and you are putting the stigma, then inquiry is required. This is the settled law.
Well, we have
That is
issued
the settled law. If you're going to the misconduct, if you're telling that it is not a misconduct, I will record your submission herein now is setting aside this.
my lord,
If you say that it is a stigma, then once you go for the stigma, then opportunity of the charge inquiry is required.
no, my lord, opportunity of hearing was granted.
No, charge sheet if the stigma is coming, then the regular inquiry is required to be conducted.
My lord, she has been issued a experience certificate. Had it there been a stigma, there she would not have been issued, because, my lord, in case of
See, you have given them a good certificate and tomorrow you have been terminated. What purpose should be served?
my lord,
You might have been, because you have not given the charity the certificate. She has done the job. You have given the certificate.
Yes.
Now the question here with regard to the termination, whether that is a stigma or on probation as a contact employee. If as a contact employee, one line you can terminate. But this court has not accepted and given an opportunity. When the opportunity is given, you have taken all the things as a ground for dismissal.
Now,
for
my lord,
termination.
here in the issue crops up, my lord, when the court has remanded the matter for a fresh consideration, or fresh hearing by the review committee, my lord, she was the one to file the representation. She was the one to bring up the issues. Now, pursuant to that, my lord, the hearing before the committee has gone.
has gone and ultimately culminated into the order.
At the, before the committee, once he has received, you have received the total document.
My lord.
Have you submitted the allegation against her?
My lord,
It's a statement of charge has been supplied to her.
my lord, after we received the representation, my lord, we sought for certain clarifications.
From whom?
From the petitioner. Now she has then further clarified. But those documents are required to be put forward before your lordship, my lord.
File the affidavit. Already filed the affidavit.
My lord,
Then
I have, my lord.
so
But,
when the court is going against you, then you want to file the supplementary. So this court is not that so lenient.
my lord, the
He
clarification,
was there. And both sides, for the petitioner, for the respondent.
my lord,
And I know the pros and cons of both sides. And I also know how the bench hunting is going. When this case was adjourned, I will call your officer here in now, 5th of February. Today, 20 days has passed. You are not prepared the document. You are asking the after 20 days, you are asking the time. When the court has opened the mind. Playing with the employee. It is very easy to give this employee to the educated person and terminate.
but kindly comes to the documents. My lord, page 38 was the first document.
Page 38. Yes.
She was called before the committee for her appraisal of her performance.
Appear before the committee for appraisal of her performance. Correct.
My lord. But this is, my lord, in terms of her appointment letter, she was appointed for a fixed period and her performance was supposed to be appraised.
Correct.
My lord, thereafter, my lord, at page 41, that is the decision communicated to the petitioner.
Yes. Page
41.
41. So after this, what has happened? This who has given this letter? The page 38. Chairman has issued to the petitioner. Page 38. With reference to the terms and conditions of the appointment letter, you are requested to appear before the committee.
My lord.
When? On 7th February.
7th February 2000.
Correct.
Yes.
So what has happened, sir? 7th February?
7th February, my lord, she didn't appear.
She didn't appear. And directly you pass the order on, that is page 41.
Page 41.
She has not appeared and you pass the order on 41. Correct.
Page 41 is the
correct.
Order, yes.
I am asking sequence you come.
Yes, my lord.
So this is 38. You issued the notice to come on 7th February.
My lord.
She didn't turn up.
My lord.
And you passed an order on 29th of February. 29th of February. In between, she has not appeared on 7th February. Have you issued the notice to her before termination? No.
Before termination, my lord, after
then what has happened?
Thereafter, my lord, after page 41, my lord, she appealed. She filed the writ petition, my lord.
She filed the writ petition challenging this order.
No, after she made representation, then filed the writ petition.
Correct. Representation is 42.
Yes.
Yes, then?
Well, kindly comes to the order passed by this honorable court at page 58.
Page?
58.
58. Yes. Now come to page 61. Last. Dispose of giving liberty to a petitioner, make a comprehensive representation before the chairman. And for so and so, in the event representation made fortnight, the date along with the supporting document, this shall be considered after giving an opportunity.
Page 60, my lord, she praised that her
submission has been recorded.
Correct.
My lord, she praised that she may be offered an opportunity of to appear
Correct.
before
Now,
the com-
now the conclusion part,
Yes.
page 61, last paragraph, and 62, first paragraph. Correct.
Yes.
Then,
Then in terms of this honorable court's order, my lord, there was a delay in conducting, contempt was filed, those things are there, my lord. But in terms of this honorable court's order, my lord, no,
page
here,
67,
page 64 is the first the notice, my lord.
page 64. 64 is,
Notice.
who has given this?
The chairman, the
The
then
written
chairman,
representation to the chairman.
chairman of that project.
You are requested to present online. So yes, she has she has made a written representation.
Yes.
Then 64. Notice, their notice.
Well,
Then
67, she made her representation.
67. No, prior to the, what is the 66?
66.
That is the main. Come to the 66.
Yes. 66 is the queries raised. No, before the queries, my lord, this is my lord, dated November, 12th of November. But before that, my lord, on 10th of November 2021, my lord, she made a representation. That lordship will find from page 68, although this is not on record, but at page 68, my lord, serial number 2. At that page, this is a daily order sheet.
Written representation was received on itna. Yes.
She made representation.
Correct.
Look.
So now thereafter?
Thereafter, my lord, these queries were raised. After considering her representation,
yes,
it is from her representation that these queries were now being asked to her.
Yes. During your tenure, how many reports have been submitted?
But this is all regarding her conduct in the project itself. No.
So that's why I am asking. Now kindly come to 38. 38. This is the first allegation. Page 38. Appear before the reviewer for appraisal of your performance in the project. This ask for. So, and now kindly come to the 66.
Well,
you have improved this.
But this is like appraisal in the project is just a one line. Appraisal would mean, my lord, her performance in the project is going to be looked upon. What she is performing in the project, my lord. And my lord, these are the queries relating to her performance in the project itself. It is not a charge like theft or anything like that. This is relating to her project, her performance in the project over the time she has been engaged.
Then,
well, thereafter, my lord, she replied to this at page 67. This is only the covering letter. She has given a detailed reply to this.
When is the impugned order?
Impugned order, my lord, is at page 93.
93.
But the conclusion drawn from the online hearing, this is the mid of the page, the conclusion drawn, the date of appointment, these are the...
now kindly come to the answer to one by one. Kindly come to page 66.
Page 66, yes.
Page 66, clause 1. As per responsibility of your post and nature of job, the center so and so Visabharti what you have done to fulfill the center targeted during the job period of approximately 4 to 10 months. What is the answer to your in the order sheet? How you dealt with the first query which you raised in the page 66? Where is that answer?
That query, my lord, has been answered by the.
Correct. Where is that your conclusion?
Yes.
So you have raised 9 queries. Can you come to the conclusion of 9 queries? Which document you have considered and you are not satisfied?
My lord, the conclusion is, my lord, serial number 2 at that page 93. It starts from serial number 2.
Yes. The online interaction so and so chairperson so and so was held. No problem. Exhaustive representation, no problem. Continuation
Well,
online so and so.
in our-
Now conclusion.
Yes.
Now conclusion. The letter of appointment of so and so temporary project rules. There is no problem. Now B. The letter also mentioned about the probation period, the appointment of so and so assigned to authorities time to time. Then no problem. Now the letter further mentioned this is a condition of the appointment letter. Now, where is the allegation? This 9, she has not fulfilled, which you asked the queries. Where is that?
Conclusion states, my lord, first of all, it refers to the temporary nature of job. Secondly, my lord, because she was in probation.
That's why I'm telling. If it could have been, if that is only the page 38, the page 93 could have been accepted. But in the meantime, you have raised 9 queries. These 9 queries. So the petitioner has submitted the reply to you. So this non-query has to give the finding. Where is the finding of these 9 queries?
My lord, the G1G at that page, my lord.
Yes. Yes, leave application as claimed to have been submitted so and so does not have any approval or even acknowledgement by the appropriate authority of CF. Hence, the post of question and hence this poses a question as to how could she leave station without the authorization. That is one. That is where is that? She come to page 66. Which question? This one.
Leaving the.
That is question number 8 might be. But you join it did not apply for further leave. That is the question number 8. Correct.
Well, these queries, then again, her answer has been considered, and then the.
Sir, now you are making the submission. Petitioner is making the submission. The court has to give the finding whether the submission of the petitioner is to be accepted or the respondent is to be accepted. Finding, then the conclusion. So where is the finding of this 9 query?
Well, the broad conclusions are at page 93.
93.
I cannot point to point reflect to 66 because
No.
66.
That's why your case is that after the order passed by this court, the petitioner has submitted the representation. On the basis of the representation, you have made a further query to the petitioner. There are 9 queries. The non-queries has to give the answer. You are telling that the yes petitioner given the answer that is not inclusory. You want to finally supplement it. That is separate issue. Once the petitioner has given the query answer to this 9 query, correct? So this query has to be adjudicated by the authority. Correct. And each and every query has to be adjudicated. Finding is to be given. As regard 8, you are telling that this is a leave. Your finding is that the question has to how she has left the station without the authorization. No problem if she has not given the authorization. Only if she has left the authorization without the station leave permission, that amounts to the termination. And what about the other? Kindly come to the other. During your tenure, how many reports you have submitted? Where is the answer? How many reports? You have given the finding on that. She has submitted so many so and so reports.
Well, the queries which the petitioner might have satisfiedly answered, but may not have.
Show me the yes, you are satisfied with the queries and the answer given by the petitioner. Show me. That's why you are not given the findings.
But the fact that he has replied to the queries, my lord,
It's there, my lord, at the order sheet at page.
But it is in the reply, my lord, we have committed the mistake at the point of time, my lord, not enclosed with the writ petition, but in reply, that I have mentioned this matter, page 12 to reply, 223 pages, 241. My lord, these entire questions have been replied in terms of their, my lord, the question put up by the authority.
No, that's I'm telling. No, he's not denying that you have not given the reply. You have given the reply. So once if authority has raised the query and she has the petition has given the reply, so where is the finding that the reply is not satisfactory?
And at the same time, my lord, the previous round of writ application order may kindly be looked into. Direction was given to adjudicate my representation,
Correct.
first representation filed, then subsequent representation at their instance.
After considering the materials on record, my lord, these are the 8 findings which have the university has arrived at. My lord, the first was regarding the leave. Then my lord kindly comes to 3. 2 is, my lord, it's not really a finding. It says he has accepted. He knows about the terms of our appointment. My lord, 3 in our reply, my lord, talks about the assignments, duty, the teaching assignments.
The teaching assignment made to the Bidisha Banerjee were not made by the authorities of the CFL project. Hence, do not come under the project duties of the teaching assignment made by so and so. Where's the teaching assignment? Kindly come to the page 94 and question 3, answer 3. Can answer to which query?
Well, teaching assignments, the petitioner has taken up this point that I have been teaching. Well, this would not be a query, my lord, because
Sir, you show me the answer to these 9 queries.
well, the findings are, my lord, in relation to the queries, but it cannot be shown that particularly first query answer is this is the answer to the first query, this is the answer to the second query. It is not been done like in that fashion. Okay, my lord, it is the queries has been raised, the answer has been considered, and then the 5 or 8 findings have been concluded. The conclusion of the 8 points in the page 93.
Ah.
Well, this does not into point to point refer to page 66. So this is the.
So once you have raised the query, you have to give the answer. Once you give the queries and the petition has given the answer to you, so you have to take a decision. The answer given by the petition is correct or not. See, a charge is framed. Article of charges is there. Then petitioner or the charge officer has to file the reply to the each and every charges. Then charges has to be proved. So it is then.
66 is not a charge sheet.
Sir, what is?
It is these are the queries. But charge sheet is a statement of allegation.
Leave aside, coach. I am not on the charge sheet. Why you have raised the query for adjudication? So she has given the reply to the query. So where is the finding of the queries?
I humbly submit, my lord. Well, had this 66 been the charges framed against the petitioner, my lord, then the.
I am with you. You are not framed the charges. But once the petitioner has given the representation, so your authority thought that yes, her representation is to be considered, taking by clarification, giving asking a clarification from the petitioner. So you have given the 9 queries to the petitioner for clarification, and petitioner has given the clarification. So this query, so what purpose you have raised the query if you are not able to decide this? Why you have raised this query? This is to be decided.
Well, these queries have been decided at page 93 by the order.
So that's why show in the 93 show that all the queries has been dealt with.
Well, this has been dealt, my lord, in a
record and order.
Well, only one point, my lord, may I just. Well, the orders, the findings at page 93 and 94, my lord. These are, my lord, has pointed out the petitioner's lack of ability to perform on the project. Well, this is not a enumerated misconduct, my lord. This is only
Judgment, my lord, where the Supreme Court has said that negligence is not a misconduct. These are merely negligent act on the part of the petitioner.
বলো সাইটেশনটা
Paragraph 16. In terms of her appointment letter, my lord, her performance in the project was supposed to be reviewed from time to time. But that review exercise was not done within the first 1 year or 2 years. This has been done a little belatedly. My lord, until and unless a unless a review is done and the confirmation is given by expressly by writing, my lord, she cannot be held to be a permanent employee. Now, she is not a permanent employee, that's an admitted fact. She is a project employee. Now, my lord, in terms of our appointment letter, the review of her performance, which was due, my lord, that has been done in this fashion. And my lord, the points raised in page 93 impugned order, my lord, these refers to, my lord, if I may say, my lord, these
Okay,
are
okay, then kindly come to the page 94, question 7, answer 7.
yes. Answer 7 is the refers to the answer given by the petitioner.
Correct.
Yes.
So that's why kindly read it.
Ms. Vidisha Bhattacharya's representation on queries 1 to 7 lacks any credential evidence, and most of the responses are evasive by citing lack of sufficient data and fictitious submission to former authorities. My lord, this is her justification given. My lord, the finding arrived at by the university, my lord, at these 8 points at page 94. My lord, these are, my lord, lack of ability of the petitioner to perform in the project, and hence, my lord, upon reviewing her performance, my lord, she has been terminated. My lord, the judgment I handed over kindly considers paragraph 16.
Yes.
That it could be seen that the word misconduct, though not capable of precise definition or reflection, receives its connotation from the context that the delinquency in the performance and it in effect of the discipline and the nature of the duty. It may involve moral turpitude, it may be improper or wrong behavior, unlawful behavior, unwillful in character, forbidden act, a transgression of established and definite rule of action or code of conduct, but not mere error of judgment, carelessness, or negligence in performance of duty. The act of the act of complaint of mere forbidding quality and character. It has to be construed with reference to the subject matter and the context hearing that the term occur regarding being had to do with the scope of the statute and the public purpose it seeks to serve. The police or the police service, my lord, the point I'm harping, my lord, is the lack of ability to perform in the project and the negligent towards her duty, my lord, is not a misconduct and it does not require a full-fledged inquiry.
Last 3 lines, read the last 3 lines. On what context this observation was made by the court?
The police service is a discipline service and it requires negligence, my lord, is
with regard to the defense of the authority, disciplinary authority, that is something different. Here I am not telling. The court only raises a question. On that day also I raised the question. You have taken the time. Now you come. So, the court has passed an order. And she made a representation.
Well, I can understand the court's query, my lord.
She made a representation. She made a representation. On the basis of representation, you have made a query, clarification. She has made a clarification. If you are not satisfied with the clarification, you could have given the reason. Only stated that the responses are evasive by citing the lack of sufficient data. What data, what you are required, she has not done. She is required, what is the scheme? She has to do this, but she has not done. So this is the scheme, she has not done. Where is that?
Well, I can understand what is falling from the lordship, my lord.
I tried my best, my lord.
What can be done? Yes.
My lord, if this honorable court kind enough, my lord, to accept my contention, my humble submission, my lord, let my service be restored, my lord. At the same time, my lord, I am not,
Cannot be. You
I
can.
am not
What
getting,
is that? Your term-
not even, my lord, subsistence allowance during this period, my lord. That being the situation, my lord, even, my lord, if this honorable court set it aside and
320.
relegate this matter before the same authority, lordship knows, my lord, the authority of administrative authority suffers from some sort of ego. My lord, I have a judgment I will intend to produce. My lord, it says, my lord, relegating before the authority to some extent draconian. At the same time, my lord, the same order, their mind makeup has been set up. So, my lord, the same thing will be done, my lord. Otherwise, certain direction may kindly be given, my lord. And if the fresh inquiry is, my lord, directed, my lord, I am entitled to, my lord, some sort of financial benefit, my lord. That is my humble submission, subject to correction.
That is troubling this court. 2022 terminated. You not obtain the interim order.
No,
25. If today the court is set aside, then
True, my
why-
lord.
the
First
how-
round of litigation, they have decided, they have made a clear cut.
without any work, how you will be entitled to get the
Well,
payment?
they have categorically stated before the court, we intend to make fresh look is to be given. And this is the nature of fresh look, lordship was kind enough to see. And we are waiting for that, my lord, that being the situation. Now, my lord, I am ready and willing to perform duty, to do work and everything. In the event after disciplinary proceedings have been terminated, my lord. My lord, if this court will kindly allow me, my lord, I can produce two judgment, my lord, subject to the leave of this honorable court, so far the financial benefit is concerned. Subject to the leave of this honorable court only. My lord, may I? May I? My lord, lordship, kindly see, my lord, this is 1991, 3 Supreme Court cases, 291. Madam, directly, lordship, I am taking your lordship, my lord, page number, paragraph 8. My lord, this is page number, paragraph 8, 296, 297, 298. In the instant case, in the affidavit file, 8, my lord. That he was practicing as an income tax advocate ever since, but however, he asserted that he has got his first brief and so and so. These averment are contradicted by the other side. Under these circumstances, we cannot make a roving inquiry, nor would it be possible for the corporation to unearth the income which the petitioner would have derived as a practicing advocate. There are many imponderable and conjectures too. Under these circumstances, we ask both the counsel to suggest a solution. We have heard both the sides on this aspect elaborately. Sri P.P. Rao, learned counsel for the petitioner, submitted that even if the relevant period is to be treated as one of suspension pending inquiry, the petitioner would have been entitled to the subsistence allowance till his reinstatement. That at least should be the criteria in granting back wages. In a situation like this, we think this is a reasonable and fair suggestion. But this is one fold. The other judgment is, my lord, this is reported in 1988, 1 Supreme Court cases, 236, paragraph 22. But before paragraph 22, my lord, page 227, 257, before we part with this, we must indicate that reliefs the appellant would be entitled to, now that the order of dismissal is set aside and proceedings have been restored to the stage of inquiry. The appellant shall be deemed to have been restored to service. The appellant would have become entitled to the normal relief available in such a situation. He should be deemed to be in service, and we do not agree with Dr. Anand Prakash, and his suspension should continue. His suspension, which had merged into dismissal, has been vacated. It shall, however, be open for the employer to make any direction as is deemed appropriate in that behalf in future. The appellant, however, therefore, became entitled to the salary for the past period, subject to his satisfying the authorities that he has not earned any other income during that period. The appellant shall be given a reasonable opportunity by the inquiry officer to meet the charges, and the inquiry shall be completed within 4 months. The appellant has personally assured us, court, that he will fully cooperate in the inquiry. Well, that being the situation, my lord, my humble submission, my lord, this is my only avocation. I am a learned person, my lord. I am a professor, my lord. Completed my PhD degree from Delhi University, and then joined, my lord, the Vishwabharati University. Now I am a, my lord. Nowadays, lordship knows, my lord, to have a job, my lord, is a difficult task.
But you kindly come to the page 94.
Lordship,
Page 94, 6.
My lord, this is relating to my lord Tikraj Basandi.
No,
My
no,
lord,
your writ petition page 94.
94. Lord.
94, clause 6.
94, my lord.
Yes.
Clause 6.
Hmm.
The email of the chairperson dated being forth.
What is this email? Where is that email?
My lord, 12/4/2016 brings forth the point of Bidisha lacked sincerity towards assigned work, used to be frequently on leave and needed frequent medical support for himself, herself, and parents. The email statement is quoted as follows. Lordship, kindly see, this is in the year 2016, and I have been terminated, my lord, in the year 2020. I took leave, authorized leave. Only 2 days, my lord, overstay. That was in my lord Delhi. I have treated myself in a government hospital. I have produced each and every document. Even if this is there, my lord, that is merged with that particular, my lord, termination order, my lord. They did not raise any question at that point of time. Possibly they are satisfied. It is to be presumed they are satisfied. That being the situation, my lord, subject to correction, my lord. And my lord,
the petitioner has filed the present writ application challenging the order passed by the chairperson. Who has passed? Chairperson. Respond number?
my lord, the respondent number.
Chairperson, Center for
Five.
Endangered Language and Viswabharati University, Shantiniketan, Birbhum. Dated 22nd August 2022. 2022. What is the decision? Where is the decision?
My lord, the final decision, lord, will find, my lord, page 93 onwards.
So where is the what is the final? Where is the termination?
No, my lord, nothing written. That they have supported, my lord, that particular review committee's order.
The earlier order has been supported.
2020.
That order was challenging the earlier round of litigation, which was not set aside by this honorable court.
Lordship will find from the page the order passed in 17/2/2020. That is, my lord, page 41. Passed in the year 2020.
Is the communication.
হ্যাঁ, ওখানেই termination কথা বলা আছে।
Yes. Your 41 is not set aside earlier.
True, my lord. Relegated to the appropriate authority and subsequently come to the conclusion that that would be, my lord, the order was rightly passed. So, my lord, there was a direction, my lord, to file my lord, the representation. It was taken into consideration. Adjudication. They have required, my lord, reply. I have filed my reply. Nothing was taken into consideration and come to a same conclusion. That is why, my lord, I am humbly submitting before this honorable court. As in 2016 Supreme Court, lordship was kind enough to observe, it is common experience that once a decision has been taken, there is a tendency to uphold it, and a representation may not really yield the fruitful result. At that point of time, I cannot challenge, my lord, because lordship was kind enough to relegate this.
For the setting aside this order.
No, my lord, I have. Lordship, kindly see, my lord.
No, at that point of time when this court has passed an order.
Yes, my lord, it's relegated before the authority.
But the order remains.
My lord, my humble submission before this honorable court allow me to continue to act as an assistant professor.
But kindly come to the page 50, 61, 62, 61 and 62.
61, 62, my lord.
Yes.
61, 62, in the event the representation is made within a fortnight from date and also supporting document. Lordship, kindly see, supporting document.
Correct.
The said representation shall consider. My lord, they consider not only subjective consideration, it is objective consideration. And same after
I am not on that.
Lordship.
When the order was passed,
yes,
61, 62.
Lordship.
41 was there.
Yes, my lord.
So you are remain terminated on that day.
True, my lord.
Correct.
True, my
and
lord.
This order, your termination was not set aside.
Lordship.
So what remains further?
Here, my lord, they have on the same opinion, my lord, in spite of, my lord, representation given by me. That was taken.
Satisfied this court.
Lordship.
Once order of termination is already in your head.
Yes, my lord.
Correct.
Lordship.
You challenge this termination.
Lordship.
This termination was set aside, not set aside.
Lordship.
Only given a liberty to
If-
file a representation.
Yes,
You file the representation dismissed.
So, my lord,
So
it wa-
how this court can go to the 2020?
No, my lord, it was
Once the
whether,
court has not entered into-
after citing all this reference and all this document before the authority, whether it is properly considered by the authority, I put this question to myself. I don't want to quarrel with them, my lord. That being the situation at that point of time, it was relegated. I was there. And my lord produced all document before the authority.
देखो, क्या बोला? (2022) wherein it is held that the decision of review committee taken on 17th February 2020 seems to have been taken after considering the duties and responsibilities fulfilled by the Mrs. Vidisha Bhattacharya. The petitioner was appointed as
The assistant professor,
assistant professor,
the
temporary project
Center for Endangered Language.
project, Center for Endangered Language within bracket CFEL, Vishwabharati on 13th of April 2015. Since then, the petitioner was working as assistant professor in the said institute. Full stop. On 11th of February 2020, a notice was sent to the email was sent to the a notice by an email was sent to the petitioner requesting the petitioner to appear before the review committee for appraisal of her performance in the project over the last 4 years on 7th of February 2020 at 11:30 a.m. in the office of the chairman. Full stop. The petitioner has not appeared before the committee in terms of the email dated 11th of February 2020. Accordingly, on 17th of February 2020, a review committee has taken a decision with the approval of the competent authority by terminating the service of the petitioner after 1 month from the issuance of the email dated 31st of March 2020.
But in the prayer number A, I have made the submission, page 30-31. Setting aside of both the orders.
Being agreed with the email dated 29th of April 2020, wherein the service of the petition was terminated, the petition had preferred a writ application before this court, being WPA 9886 of 2020. The said writ petition was disposed of by an order dated 24th of August 2021 by giving a liberty to the petitioner to make a comprehensive representation before the chairman, Center for Endangered Language, highlighting her grievances, and directed the respondents to consider the representation, if any, made by the petitioner by giving an opportunity of hearing to the petitioner and to pass a reasoned and speaking order within a period of 6 weeks from the date of receipt of the representation of the petitioner. Full stop. In terms of the order passed by this court dated 24th of August 2021, the petitioner has made representation to the authorities. On receipt of the representation of the petitioner, the authorities by a letter dated 12/11/2021. 2020, what is the date? Page 66?
Page 66, my lord.
What is the date?
12/11.
12/11 year?
21.
21?
Yes, sir.
2021. 12/11/2020. By a letter dated 12/11/2021 has asked for about 9 clarification from the petitioner within a period of 15 days from the date of receipt of the said letter. On receipt of the said later, comma, the petitioner has submitted her clarification to the respondent authorities. Pull it. After considering the clarification made by the petitioner, comma, the authorities have passed the impugn order. Pull it. Learned counsel appearing for the petitioner submits that the petitioner has made a detailed representation as well as the clarification as per the queries made by the authorities. But the respondent authorities have without considering the representation submitted by the petitioner as well as the clarification made by the petitioner, comma, the authorities have passed the impugn order. He submit that initially the authorities have issued an order on 11th of February, have communicated the decision to the petitioner by an email dated 11th of February 2020, wherein initially the authorities by a communication dated 11th of February 2020 requested the petitioner to appear before the review committee only for the purpose of appraisal of the performance of the petitioner in the project for 4 years. But unfortunately, the petitioner could not appear before the authority as the petitioner was at Delhi, and the said fact was at the knowledge of the petitioner authorities. But in spite of the same, without giving any opportunity of hearing to the petitioner, comma, the authorities have taken a decision for termination of the service of the petitioner after issuance of 1 month termination of the petitioner, which was communicated to the petitioner on 29th of February 2020. Okay. Full stop. The land counsel appearing for the petitioner submits that the initially the petitioner, the respondent have issued the notice only with regard to the appraisal of the petitioner for performance in the project for 4 years. But subsequently, the respondent authorities have made several queries by a communication dated 12th of November 2021. And in the impugn order dated 22nd of August 2022, the authorities have considered the incident of 2016, which was not the subject matter. Fully so. He further submits that the authorities have also not discussed the clarification made by the petitioner in terms of the clarification, in terms of the notice issued by the authorities on 12th November 2021. Police. The counsel for the petitioner has relied upon the judgment in the case of Om Prakash Goyal versus Himachal Pradesh Tourism and Development Corporation Limited, Shimla and another, reported in 1991, Volume 3, SCC 291, and submits that the petitioner was terminated by a communication dated 29th of February 2020. But this court by an order dated 24th of August
2021.
24th of August 2022. 24th of August 2021. Given liberty to the petitioner to file a detailed representation. And the petitioner has filed a detailed representation, but the authorities are not considered. And as such, the impugn order is required to be set aside and the petitioner may be reinstated in the service. He further relied upon the judgment in the case of Tekraj Vasandi alias K.L. Basandi versus Union of India and others, reported in 1988, Volume 1, SCC 236, and submits that once the proceeding initiated, when the order of dismissal of the petition is set aside, the petition is to be reinstated and all the consequential benefit is to be provided to the petitioner. Per Quantal, an advocate appearing for the respondent authorities submits that initially the authorities have issued a notice to the petitioner to appear before the review committee for appraisal of her performance in the project over the last 4 years. But the petitioner, in spite of receipt of the notice, failed to appear before the authority. And as said, the authorities have no other option has terminated the service. He submitted that the petitioner was not the regular employee. He has been appointed on a temporary basis in a project work. And as such, the petitioner cannot claim the benefit equivalent to the regular employee. He further submit that after the order passed by this court, the petitioner has submitted the detailed representation. And on receipt of the detailed representation, the authorities was of the view that some clarification is required. And accordingly, by a letter dated 12th of November 2021, the authorities have requested the petitioner to clarify requested to file the clarification. And the petitioner has filed the clarification. After considering the clarification, the authorities come to the conclusion that the clarification made by the petitioner is not justifiable, and as such, the representation submitted by the petitioner was rejected. The counsel for the petitioner and the counsel for the respondent relied upon the judgment in the case of Syndicate Bank versus Vidya G. Nayak, reported in 2001, Volume 2, LLN 952, and submit that the act of the petitioner is not a misconduct. It is only a negligence. And as such, no regular inquiry is required to be initiated against the petitioner. Had the learned counsel for the respective parties peruse the materials on record and the document and the judgment relied by the parties. This court find that on 11th of February 2020, the respondents have requested the petitioner to appear before the review committee for appraisal of her performance in the project over the last 4 years on 7th of February 2020. The petitioner could not appear before the review committee. Full stop. Immediately on 17th of February 2020, the committee has taken a decision for termination of the petitioner from service. And the same was communicated to the petitioner by an email dated 29th of February 2020. The document which the petitioner has relied upon established that the petitioner was not at Kolkata. It is Kolkata, na?
Howrah, my lord.
In West Bengal. And is out of West. She was in Delhi.
Delhi for treatment, my lord. That is page, lords, you will find page 39.
She was in Delhi
and 40
under medical treatment.
Lords.
From 5 to 2020 to 20th to 2020. 20th to 2020. 20th to 2020. Thus, full stop. Yeah,
She was under medical treatment at Delhi from 5 to 2020 to 20 to 2020. Full stop. The petitioner has challenged the said order of termination, communication of the order of termination. Full stop. This court, by an order dated 24th of August 2021, has passed the following order: 6162. ठीक है? The petitioner has made a detailed representation to the authorities. On receipt of the representation, the authorities have authorities by a communication dated 12/11/2021 ask for the following clarification, page 66. Page 66, huh? 1 to 8. This one. The authorities have asked for about 9 clarification from the petitioner. By the impugned order, the authorities have come to the conclusion that the representation, the questions raised by the authorities from question 1 to 7 lacks any credible evidence, and most of the responses are evasive by citing lack of sufficient date of fictions submission to former authorities. Full stop. This court failed to appreciate that the authorities have initially terminated the petitioner only on the ground that the petitioner has not submitted the appraisal of her performance in the past project for the last 4 years, as per the date fixed by the authorities. But subsequent to the representation received by the authorities in terms of the order passed by this court, the authorities have raised certain other issues which was not in the original issues on the basis of which the petitioner was terminated. Full stop. In the impugned order, at paragraph 6, also in paragraph 6, the chairperson has taken into consideration the email dated 12th April 2016 and alleged that the petitioner lacked sincerity towards assigned work and used to be frequently on leave. The said charges or / allegation not in the original notice on the basis of which the petitioner has been terminated. Full stop. This court this court, by an order dated 24th of August 2021, directed the petitioner to file representation and given liberty to the petitioner to file a detailed representation, and the authorities are directed to consider the same. But the respondents herein, instead of considering the representation of the petitioner, have made several other allegations which was not in the originated not in the original notice dated 11th of February 2020. The authorities also failed to consider that in the email dated 11th of February 2020, the petitioner was directed to appear before the authority on 17th of February 2020. Subject 7 over 17 hai. 17th of February 2020. But the petitioner has disclosed the document to show that the petitioner was under medical treatment at Delhi from 5th February 2020 to 20th February 2020. The said aspect has also not been considered by the authorities. Considering the above, this court find that in the case of Tekraj Vasandi, Supra. The Honorable Supreme Court has held as follows. Paragraph 22. Check out, no? 22. In the present case, one notice was issued to the petitioner directing the petitioner to appraise the authorities with regard to her performance for the last 4 years in the project. But the petitioner has not appeared before the authority as she was under medical treatment. But the respondent authorities have not considered the same and terminated the service by a communication dated 11th of February 2020. Full stop. The petitioner, as per the leave granted by this court, the petitioner has submitted the detailed representation. On receipt of the detailed representation, the authorities have raised further allegation against the petitioner by a letter dated 12/11/2021. Considering the above, this court finds that the authorities have exceeded their jurisdiction by incorporating further allegation against the petitioner on receipt of the representation submitted by the petitioner. This court also finds that in the impugned order, the authorities have taken into consideration of the email dated 12th April 2016, which was not the subject matter on the basis of which the petitioner service was terminated. Considering the above, the impugned order dated 22nd of August 2022 and the email dated 11th of February 2020 are set aside and quashed. Full stop. However, the quashing of the proceeding will not prevent the authorities to take fresh steps against the petitioner if the authorities intend to initiate any proceeding against the petitioner. As the petitioner was terminated and she has not worked in the department, but the petitioner shall not be as the petition has been terminated on 17 with effect on 17th of February 2020. Thus, since then the petitioner is not performing any duties with the respondent authorities, the petitioner is not entitled to get any back wages, but the petitioner is entitled to reinstate in her service from the date of receipt of this order.
My lord, deeply obliged, my lord. My lord, he will be, my lord, go back, my lord. She will go back, my lord.
I get a pass and all.
From that. Well, disciplinary proceeding will continue and she will be reinstated.
Given liberty, if they want to proceed, they can proceed.
Well, she will be reinstated.
Reinstated.
Deeply.
But you will not get the back wages.
Deeply obliged.
You will not get the back wages.
Deeply obliged.
But I pay for the picture.
Maybe
file the affidavit in
Well, the affidavits have been completed. Please fix a date period after, sometimes in the middle of March.
Middle of March. Affidavits completed?
Yes, affidavits
Where we are filing the affidavits.
There is one confusion. Two affidavits have been used by respondent number 11, right?
10. Two affidavits? No, acha.
One affidavit has been used. One affidavit has been used by respondent number 11 and 12 jointly. Another affidavit in opposition has been used by respondent number 11 singly. Now, my lord, we have filed our reply to the affidavit in opposition filed by respondent number 10. So, that may be completed. Kindly, fix a time, so that now it is ready. And there is urgency in the matter. I think Learned Advocate General would appreciate that.
And if the other affidavits could be circulated. No, not of Mr. Mozumdar. Mr. Kundali has affidavits maybe.
Yeah. Kindly give us a date and time, subject to lordship's kind convenience, obviously.
Mr. Datta, you are appearing for?
But I am being
State 10. 11, who is 11?
দুটোরই দিয়ে দিবি।
Mr. Kundalia is appearing for the 11. And Union of India,
এটা কি?
11 will also file the affidavit.
11 has filed and 11 and 12 have
12 are filed.
no,
Double.
So what do we do? I put the question to myself.
Yeah, there are two affidavits.
There is one DGGI and one DGGSTI. The GSTI I am appearing, DGGI another set of.
No, but one affidavit is 11
Yes.
and another affidavit is 11 and 12.
My lord, that may be recorded as only on behalf of respondent number 12.
12.
Very well, madam. Then we will do that. Very well. ওটা 12 এর ধরে নাও। 11 and 12 টা 12. 11 কেটে দাও।
So you file the affidavit.
We will take 3-4 days. We will do that. It will not take much time. Kindly give us a date, my lord. Kindly give us a date. At present, the main answering respondent is the state.
না আগে তো পার্টি এড করতে হবে, দ্যাট ইজ কেপ্ট রিজার্ভ।
April, March, any date, in the month of March.
May I only make one suggestion? Your Lordship has recorded, my submission in the previous order that there are various other authorities who are required to be added or brought on record. My Lord has been pleased to reserve that issue for your Lordship's consideration. I was praying this, whether it is April or March. First, kindly decide whether the other authorities which has been pointed out by me and recorded by your Lordship.
But on March, we will come back. In March, we will come back.
Please hear us on that issue. I mean, the state on that issue, and then the other.
But this is a unique case. Unique case in the sense, my lord, I am very happy to note, my lord, that this is a case where, my lord, we find state and union speaking in the same voice,
right.
which is very, very rare these days, my lord.
Because after all, it's a fiscal matter, GST issue, it has to.
The GST matter.
I hope in all matters.
This kind of, my lord, this kind of coordination is lacking in other matters.
That's why I'm telling you.
My lord, and what's
If
more,
this coordination
what's
will
more
continue,
relevant for
there will
me
be no
that,
problem.
perhaps, my lord, the petitioner has done a great service to the nation by bringing the two entities
together.
And yeah,
this is a very rare thing we have. But it's not a question of money, my lord. I will explain that. Well, we'll come back. We'll come back. Kindly give us a date, my lord, subject to your lordship's convenience.
25th March 12 noon hai. Respondent number 10 filed affidavit in opposition after serving the copy to the London Council for the petitioner. Petitioner has also filed affidavit in opposition, affidavit in reply. Let the same be kept with the record. And this, it is fine from the record. There are two affidavits on behalf of the, one on behalf of the respondent number 11 and another on behalf of the respondent number 11 as well as respondent number 12. Counsel for the respondent number 12 submit that the affidavit in which it is mentioned that the affidavit on behalf of the respondent number 11 and 12, that is to be treated only on behalf of the respondent number 12, not 11. Counsel for the petitioner press for time to file affidavit in reply to the affidavit in opposition filed by the respondent number 11 and respondent number 12. Let affidavit in reply be filed within 1 week.
Sorry, my lord.
1 week. Reply
1 week, my lord.
within a week. Will release the matter on 25th of March 2026 at 12 noon.
I'm grateful.
My lordship is giving us as a date, my lord.
25th March.
Okay.
Hmm, 12.
12. Great.
I appear for the respondent.
Yes.
On the last occasion, my lord, I just started my argument. This is, my lord, in respect of, my lord, section 208-210 of the, my lord, Companies Act. Now, my lord, if your lordship state my lord takes my lord the vacating application. So the main thrust of the argument is this, my lord, that 20210 order, the order of investigation, my lord,
did not disclose any reasons on application of mine by the central government. That is the main point urged by Mr. Thakkar. Kindly text page 18 of the application for vacating the can 1.
Can 1.
Yes.
Yes. Yes, can 1.
Yes. Lots kindly text page 18.
Yes.
May I just place it not. Whereas the central government is empowered under section 2101A and C of the Companies Act 213 to investigate in the affairs of the company in public interest. And whereas RDER by letter dated 11th of June 2021 has submitted a proposal for investigations of all group companies of Sarda Ghanshyam Govind Kumar Group companies, and the matter has been considered by the ministry. And it is of the view that the matter is serious in nature, and therefore the investigations of all the companies as may be ordered under section 210 1A and C of the Companies Act 2013 to be conducted by the RDER and RDNR for 162 and 24 companies respectively, and to submit consolidated report by both RDs for their region within 6 months in public interest. Now, therefore, in exercise the power conferred under section 2101A and C of the Companies Act 2013, the central government hereby orders investigation into the affairs of the following companies to be carried out by the inspectors appointed by the regional director, Eastern Region, Kolkata, regarding the companies at serial number 1 to 162 and the regional director, Northern Region, Delhi, regarding the company serial number 163 to 186, and submit a consolidated investigation report by the respective regions within a period of 6 months positively. Now, my lord, this is the name of the companies were given, and subsequently kindly text penalty paragraph of this paragraph number 5. Your lords would get it at page
24.
It says, paragraph number 5, the inspectors appointed by this order to investigate in the affairs of the above mentioned companies and shall exercise all the powers available to them under the Companies Act 2013. Veracity of the allegations and counter allegations of the various complaints may also be examined during the investigations, along with the unveiling of the true nature of the banking transactions carried out by the companies, and quantum of fraud involved may also be determined. So, this is the order. Now, kindly have a look. Kindly text the volume 1 of writ petition.
Yes.
Now, your lordship will kindly text page 31.
Yes.
Now, page 31, this is the inspection report under section 208. Now, this inspection report conclusion, your lordship would also get it. This inspection was conducted in view of section 2065. 2064 speaks about inquiry. 2065 speaks about the inspection. So, this inspection was conducted in terms of section 2065 of the Companies Act. Now, report on inspection. 208 speaks about report on inspection. So, report was submitted under section 208. So, it speaks about report on inspection made. If you lost Companies Act once. Companies Act. That's it.
What a book is it? Companies Act. Boda book. Acha.
Can you take my lord, section 208?
Yes.
208 my lord, speaks about my lord, report on inspection made.
Yes.
The registrar or inspector shall, after the inspection of the books of accounts or an inquiry under section 206 or other books and papers of the company under section 207, submit a report in writing to the central government along with such documents, if any, and such report may, if necessary, include the recommendation that further investigation into the affairs of the company is necessary, giving his reasons in support. So, blood 208 report, blood report is basically report on inspection. The report is submitted to the central government. It may contain, blood, the recommendation for investigation. It may not contain the recommendation for investigation. Now, blood, after 208, blood, if you lordship, blood, can you take 210?
Yes.
210, blood, investigation into the affairs of the company.
Yes.
But the central government is of the opinion that it is necessary to investigate into the affairs of the company on receipt of the report of the registrar or inspector under section 208.
Correct.
Next lot, on intimation of the special legislation passed by a company that the affairs of the company ought to be investigation. Next lot, in public interest.
Correct.
Now, my lord, it can be done also on public interest. Now, the question is, my lord, whether for the purpose of, my lord, ordering investigation, whether, my lord, a detailed reason is required or not. Whether the application of mine, my lord, should reflect in the order of investigation or not. Now, my lord, my respectful submission would be before your lordship, my lord, that it has, my lord, it cuts in both the way. If, my lord, the central government, my lord, discloses, my lord, reasons.
No, that's why the truth, because their argument is that where the central government is of the opinion.
Opinion.
So where is the opinion on that?
My lord, it is of public view, my lord. If your lordship, my lord, kindly takes, my lord, once again, my lord, page 18.
Correct.
It
Page
says, my
18.
lord, it is of, it is said, my lord, the central government is saying, paragraph 2, which says, my lord,
Submitted a proposal
submitted a proposal
for
for investigation of the group of companies of Sardar Ghanasam Govinda Kumar,
Correct.
group companies, and the matter has been considered by the ministry,
Uh-huh.
and it is of the view that the matter is serious in nature. It is of the view that the matter is serious in nature. The my response submission, my lord, these 3 to 4 words are sufficient, my lord, to form an opinion.
So
The matter is serious in nature, and therefore the investigation of the companies may be ordered. Now, my lord, your lordship, my lord, kindly consider one thing. Today, my lord, the central government is applying its mind, and my lord, the central government is forming its opinion. Now, my lord, if the detailed reasons are given, then, my lord, another way of argument will come that if the central government will not form its opinion by giving detailed reasons, then what request to be investigated by the investigating officer? It cuts in both the way.
No, that cannot be.
My lord, my submission would be, my lord, the reasons, my lord, it is a application of mind. It cannot be reflected on so many words. It is, my lord, application of mind, and it has applied that it is the in view of the matter is serious in nature. So it requires an investigation as because, my lord, one has
As per your submission, with regard to 201, when the central government is of the opinion, it is
central
necessary.
government is of the opinion.
So the order of 11th of May 2022,
Yes.
and that the ministry has considered view that the matter is
Serious in nature, and
So
that is the opinion.
So
That is the opinion. And I will not, so far as will not, I have on the last occasion, my lord, I placed before your lordship, my lord, there are certain paragraphs. My lord, kindly, my lord, let me allow me, my lord, kindly see, my lord, I just refer, my lord, 3 pages to, my lord, justify what is the fact. My lord, kindly takes, my lord, I just refer, my lord, 3 pages. That is, my lord, page 88 first.
Of the
Repetition. Volume 1.
88.
88.
Yes, paragraph 7.
Paragraph 7, will I have placed it. Now, my lord, page 89, you will also find, my lord. Page 89, next page. In the box, my lord, you will also find the revenue from operation, my lord, in 2015, 2016, my lord, 33 lakhs and 3 crores something. Thereafter, 2016, 2017, nil. Thereafter, 2017, 2018, my lord, nil. Now, my lord, other income, my lord, you will also find the details are there. The most anomaly factor, my lord, you will also get it at page 90. Page 90, my lord, you will also find
suspicious transactions.
Yes, these are the transactions. My lord, kindly see, my lord, these are the transactions. My lord, transactions, my lord, more deposited more than 4 crores.
Yes, then
Now, my lord, if your lordship, my lord, kindly takes, my lord, once again, my lord, the Companies Act, my lord, two provisions I will refer, my lord, just 223 and 224. এই জায়গাটা বের করতে গিয়ে 2022 INSSC
223.
Section 223. But section 223 says, my lord, inspector's report. It says, my lord, an inspector appointed under this chapter
Yes.
may, if so directed by the central government, shall submit interim reports to the government, and on conclusion of investigation shall submit a final report to the central government. So, my lord, this 223, my lord, inspector report, he speaks about, my lord, investigation report. This is not the report, my lord, under section 208.
An inspector appointed and is directed by the central
Inspector
government shall
appointed
submit
under this,
interim report.
if so directed by the central government, shall submit interim report to the government, and on conclusion of investigation shall submit a final report.
Correct.
So,
There
my
are
lord,
two reports.
the two reports.
One is the interim and another is the
That is, my lord, investigation.
correct.
That is the investigation. My lord, 223, my lord, speaks about the investigation, not, my lord, inquiry or inspection or anything else. Now, my lord, kindly take, my lord, 224.
Yes.
224, my lord. It says, my lord, action to be taken in pursuance of inspector's report. It said, my lord, if from an inspector's report made under section 223, it appears to the central government that any person has in relation to the company or in relation to any other body corporate or any person whose affairs have been investigated under this chapter, been found guilty of any offense for which he is criminally liable, the central government may prosecute such persons for the offense, and it shall be the duty of all officers and other employees of the company or body corporate to give the central government the necessary assistance in connections with the prosecution. So, my lord, 223 and 224, my lord, my responsible submission speaks about, my lord, investigation report. So, my lord, is nothing to do with the, my lord, inquiry report or inspection report. It is obviously, my lord, after investigation. Now, my lord, this case, my lord, is at the stage of investigation. Investigation has been ordered. No report has been submitted. My lord, they have challenged, my lord, to 217.
223 is having two parts.
223 having is two parts. Two parts.
First, the inspector appointed by the government shall submit the interim report.
Interim report.
Shall, not
submit.
so. That is the interim report is mandatory.
Yes.
Correct.
Yes.
Mandatory to the government, and on conclusion of the investigation. So that is interim report is the preliminary inquiry.
That is also part of investigation.
Correct. That's why the interim
I am
report.
submitting, my lord. It is, my lord, 223 and 224, my lord, only in respect of investigation, not, my lord, on inspection.
Correct.
My lord, kindly consider, my lord, 2064 speaks about, my lord, inquiry.
Yes.
2065 speaks about inspection. 208 speaks about report on inspection. 210 speaks about the investigation.
Yes.
Now, after investigation, my lord, the report is coming, the interim report or final report, 223, and now, my lord, 224 is the final report on the basis of which the central government would take necessary steps. Now, in this background, my lord, these are my submissions, my lord. Kindly have a look now, my lord, the judgment which have been cited. I just refer, my lord. First of all, my lord, kindly take this.
No, 224. If from the inspector's report made under 2023, it appears that the central government that any person has
in relation to any company or in relation to any other body corporate
or
other person whose affairs have been investigated under this chapter.
Correct.
So, my lord, my submission is, my lord, 223 and 224 speaks about the investigation, not on inspection. Now, my lord, kindly takes, my lord, this first judgment, my lord, which was placed by my learned friend, my lord, the coordinate bench of this Honorable Court, my lord, page 19 of the page 19 of the compilation.
Yes.
Now, my lord, your lordship, my lord, straightway comes, my lord, page 23, paragraph 15, page 23 of this compilation.
Yes.
Your lordship would find paragraph 15 speaks about, in the present case, it is to be noted that all the said procedure from 206 to 223 of the 2013 to 2013 Act were already over. So, my lord, this is the case, my lord, clearly distinguishable in this case. Now, may I just, therefore, the proceeding as emphasized under section 224 have been taken out against the petition number 1, both by initiating the criminal proceeding and winding up proceedings, which are ongoing. Hence, the clock cannot be set back, and the fresh notice and initiated under section 217 of 2013 Act. Hence, the impugned notice dated October 24, 2013, purportedly issued under section 217, bad in law, and ultimately court will not caused it. So, my lord, in that case, my lord, your lordship would find, my lord, 223 over, 224 over. Thereafter, my lord, again, my lord, clock is trying to be put back. So, my lord, in those circumstances, my lord, court had held that after concluding your proceedings under section 223 or 224, he cannot again resort the proceedings under section 217 by issuing notice under section 217. So, in this background, my lord, this judgment was delivered, and the facts are absolutely distinguishable facts. Now, my lord, next judgment, my lord, which was cited, that is, my lord, Nita Puri's judgment.
So what is the stage of this present case? Only
Only, my lord, notice was issued. 217 notice was issued. Central government, my lord, ordered investigation under section 210. Now, my lord, this notice under section 217 was issued, and they have assailed this notice, my lord, by filing this petition. Well, notice your lordship would get it, my lord, at page, my lord. Can you take, my lord, one page, my lord? That is page 30. First notice, my lord, your lordship would get it at page 205, my second volume.
205?
205.
Yes, good.
Well, this is the notice, my lord, issued to Ayushman tie-up, the petition number 1. The subject is, my lord, notice under section 217 of the Companies Act to furnish certain information and certified copies of the documents in the matter of such and such and such. Investigation into the affairs of the caption company under section 210 of the Companies Act, such and such. Now, my lord, this notice was given asking the company, my lord, to furnish certain documents, and the enclosures are at page 207. These are the documents, my lord, sought for. Now, my lord, after this, my lord, the company, my lord, kindly turn, my lord, page 301 once.
301
of this volume 2.
Yes.
Now, my lord, your lordship would find, my lord, at page 301, what company is writing. We are in receipt of your letter dated 30th of August 2023, as referred above on 4th of September 2023, issued by your good office, drawing that our attention of the Ministry of Corporate Affairs as ordered in terms of section 210, 1 of the Companies Act 2013. On perusal of the aforesaid notice, it appears there are certain implications, and in order to respond the said notice, we request you to kindly grant us 3 weeks time. So, my lord, they have submitted to the jurisdiction of the investigating officer, my lord, by asking for an adjournment and granting 3 weeks time to furnish all these informations. Now, my lord, after that, my lord, they filed this petition, my lord, challenging the notice itself.
But without prejudice.
Without prejudice. Everything is without prejudice, my lord. Now, my lord, kindly take, my lord, next judgment, my lord, which was referred. That is, my lord, Nita Puri's judgment. You also would get it, my lord, at page 114 of the compilation.
Yes.
Now, my lord, your lordship, straightway comes to page 128, paragraph 26.
Yes.
May I just place it, my lord? Crucially, the counter affidavit filed on behalf of the respondents advanced the central government had, pursuant to the complaint dated such and such by such and such president of such and such, ordered an inquiry under section 2064 of the Companies Act on 8/8/2018. The resulting inquiry report recommended that an inspection of the books of accounts and proper papers of the concerned companies be undertaken under section 2065 of the Companies Act 2013. There is absolute silence in the impugned order and also in the counter affidavit filed by the respondent as to whether such inspection was ever conducted, and if so, the outcome thereof. The amendment of the statutory courts recommended under section 2064 without any explanation, therefore, exhibits the legal lacuna, and notice notice sharing above. So, my lord, in this case, my lord, your lordship would find that 2064, 2065, though it is ordered, but there is no such procedure, my lord, adopted by the central government, my lord, or the inspector appointed by the central government. So, my lord, the procedure, my lord, which was laid down, my lord, in the act itself, that was not followed, my lord, in Nita Puri's case. But in your lordship, my lord, can you take, my lord, paragraph 30 also? Paragraph 30 says, my lord.
No, that's why then you read with the paragraph page 18 of your affidavit.
Page 18.
Page 18 of can.
Can. Yes, my lord.
Whereas while letter dated so and so has submitted a proposal for investigation.
Proposal for investigation of all group companies
Correct.
of such.
So now that's why. So where is the inquiry?
Inquiry is
206. Where is the inquiry?
Inquiry is, my lord, this is
That's why
page,
they are relying upon the judgment. Where
page-
is the inquiry on
page 31, page 31.
31 of the
Page 31 of the volume 1.
petition?
Volume 1, yes.
Writ petition.
Yes.
Okay, okay. Got it. Got it.
This is the inquiry. Well, but in that case, Nita Puri's case, my lord, there is no inquiry at all. There is no inquiry at all. Now, my lord, so far as my lord, Nita, my lord, it has been submitted, my lord, when a statute provides it to do a particular thing in a particular way, it has to be done in that way. But Taylor versus Taylor, my lord, subsequently, there are so many judgments, my lord, on the last occasion, my lord also referred those judgments. Now, my lord, here, my lord, the central government has done the thing as the manner provided in the act itself. There is no departure at all. Well, the Nita Puri's case, my lord, the section 2064, 2065 was not even complied with.
Yes.
Now, my lord, just I will submit, my lord, one judgment, my lord. That is, my lord, 2022 9 SCC 794.
Yes.
Now, my lord, your lordship, my lord, can you see, my lord? Your lordship, my lord, state comes to, my lord, paragraph 5.3.
Yes.
It's the same point was urged. The order dated 31st of October 2018 and 27th of October 2020 do not furnish the reasons or circumstances which compel the central government to form an opinion while ordering the investigation. So the point will not the same. Now will not kindly turn will not next paragraph 7.3. Will not said the union government, while issuing both the orders, was acting within the jurisdiction, and it would be improper construction of the statute to postulate that while ordering an investigation's detailed reasons have to be spelled out. On the contrary, it was submitted the very purpose of an investigation to inquire into the affairs of the company and the entirety of the material will emerge only in the course of the investigation. Now, my lord, kindly have a look, my lord. Next, my lord, paragraph paragraph 14, page my lord 801.
Niharika.
Yes, Niharika was quoted. The Niharika was quoted, and thereafter Niharika was considered by the High Court against the passing the blanket interim orders, directing no coercive steps to be taken in the investigating authorities as might hamper the investigation at an early stage. Having due regard to the material which has been placed on record, it cannot be said that the Union government had not indicated the reasons for the exercise of the jurisdiction under section 212 and 219. At this stage, the Union government was only ordering an investigation, and it would be an inappropriate to place the burden of recording elaborate reasons when the purpose of the investigation is to ensure that the full inquiry into the affairs of the companies is carried out. The third reason which with the High Court is hence specious. So, my lord, my submission would be, my lord, I cannot give, my lord, detailed reasons. If I give the detailed reasons, my lord, it cuts in both the way. They will ask, and what remains to be investigated. Nothing remains to investigate. What investigation officer will found. Now, my lord, in this background, my lord, kindly have a look, my lord, the interim order passed by this honorable court, my lord, while entertaining the writ petition. Your lordship would get it, my lord.
Order dated.
Order dated, my lord. This is not July 7, no, July 3, 2024.
3rd July.
3rd July. 3rd July, my lord, the page 15 of my application, my lord.
Yes.
May I just place the order, my lord? It says prime efficacy and arguable case has been made out. The question is whether the notice dated August 30, 2023 on similar notices could be issued under section 217 of the Companies Act 2013. The said provisions deals with the procedure, power of an inspector. Section 223 of the Act enables and empowers the inspector to conduct an inquiry and submit interim report and also the final report before the central government. Section 224 of the Act empowers the central government to prosecute on the basis of the final report. It is contended before this court by Mr. Banerjee and a senior advocate that steps under section 224 of the Act had already been taken by the central government and prosecution has commenced. The matter should not be reopened on the self-same violations and alleged offences. So, my lord, with the deepest of respect, my lord, that is not the case. That is not the case. My lord, 223 and 224, my lord, that stage has not come. With deepest of respect, my lord, that there was, my lord, mistake on our part also, my lord, we could not apprise the court, my lord, rightly. But that was the, my lord, thing which led the court, my lord, to pass an interim order. So, my lord, the 223 and 224, that stage has not yet come. It is still at the stage of investigation. And even after the completion of investigation, the 222 and 223 and 224 will come. So, my lord, the interim order, my lord,
Yes. That's all.
Yes, my lord, these are my submissions, my lord.
My lord, kindly have 223 and 224 once, please, my lord, because I think this is the main argument which is advanced. Kindly have 223, 224 once.
Yes.
And inspector, your lordship has that. Inspector appointed under this chapter may, and if so directed by the central government, shall submit interim reports to that government. And on the conclusion of the investigation, shall submit a final report to the central government. So, Malad, this inspector's report is pursuant to an inspection order under investigation order under 210. Kindly come to 210. This inspection, it's called an inspector, but it is the investigation report. Your lordship sees on the conclusion of the investigation.
No. 210 is where the central government is of the opinion it is necessary to investigate.
So investigate.
Correct.
So when it forms the opinion it is necessary to investigate, then kindly come to 2103. For the purposes of this section, for the purposes of this section, the central government may appoint one or more persons as inspectors to investigate.
Correct.
So under 210, the central government forms an opinion, then it makes an order appointing a person as inspector to investigate.
Correct.
And then that inspector, my lord, gives an investigation report under 223. So so what today, my lord, the question of 223, 224 coming in does not apply because I am challenging the very formation of the opinion and the order directing investigation under 210.
Correct.
Now, what have I urged before your lordship, my lord? Under 210, I urged that 210 opinion can only be formed on the basis of A, B, and C.
On receipt of the report of the registrar or inspector under
section 208. Now, your lordship has seen, my learned friend has very fairly told your lordship that the 208 report is at page 31.
Correct.
208 report is at 31. On acting on the 208 report, the government has accepted the 208 report. Kindly see page 31, please. Melody has shown your lordship page 31.
Yes.
208 report says, I am enclosing herewith inspection report under section 208.
Correct.
So this is the 208 report.
Correct.
The 208 report, my lord, kindly come to the last page I had shown your lordship, my lord. Page 44, your lordship kindly sees conclusion.
Yes.
Kindly see the second paragraph, major facts. Your lordship has that. Under paragraph 12, conclusion, the second internal paragraph, major facts of allegations are operation of shell companies, tax evasion, siphoning of funds and diversion of funds, fraud on bank loans, etc. These were the allegations. Then kindly see, during the course of inspection, books of accounts and other papers of the company are examined and no instance of such allegation has been found in the present companies. However, during the course of inspection, some violation irregularities of Companies Act are observed and detected. Same are reported under so and so. So, my lord, under the 208 report, it is clearly found after inspection that these allegations are not made out. So, 210 report of inspector is not there under 208.
What allegation is not there?
My lord, under 202, under there, the allegation into which the inspection was carried out under 208 was fraud on bank loans, etc.
Correct.
That has been inspected and it has been found that no such allegation is proved.
Correct.
Now, my lord, so when we come back to 210, the central government has to form an opinion on the basis of ABC.
Correct.
The ingredients of ABC are not there. And that is also not disclosed in page 18. When my learned friend shows your lordship page 18, this is not the opinion. This is an order directing investigation. Kindly see page 18. The order into investigation can only be passed on the basis of ABC. If ABC is not there, then the material to form an opinion is not there. I am not telling the central government once to disclose before your lordship the opinion, because the Supreme Court has held the opinion can be seen. I'll distinguish the judgment which my learned friend has shown your lordship. That was for serious fraud investigation, SFIO. That's a different chapter altogether. That is under a different section. That judgment will come to later. Kindly see 210 once, please. And page 18.
Yes.
Of the vacating.
Correct.
Whereas the central government is empowered under section 210, I'm not troubling with. And kindly see, and whereas RD, read a letter dated so-and-so has submitted a proposal for investigation. Now, this whole order is made on a proposal for investigation.
Correct.
Now, kindly see whether this could have been made, whether a proposal for investigation can result in a formation of opinion and order for investigation under 210. Kindly see 210 now, proposal for investigation does not form ingredients of 210 A to C.
Yes.
This is the short point I'm trying to make, my lord. What he is acting on, what the central government is ordering an investigation on the basis of a proposal for investigation.
Correct.
And proposal for investigation is not one of the triggers of 210. And is it 210 proposal for investigation is not there?
No. See, proposal of 210, whereas the central government is of the opinion that it is necessary to investigate into the affairs of the company.
Please, my lord.
Where from the central government will come to know? From the report itself?
From the report itself, grateful, my lord.
Correct. So report is now you report to kindly come to the page 31.
Please, my lord.
Page 31 to page 44, 45.
Yes, please, my lord.
So these are the report.
Yes.
So these are the report. Under the report, the conclusion is so and so, whatever it may be. So now on the basis of this report, now come to page 18.
Please, my lord.
Page 18. And whereas RD so and so letter, proposal for investigation of the group of companies are the so and so has been considered by the ministry is of the view that the matter is serious in nature. So this report has been considered and they are of the view that this is a serious in nature.
No, my lord, I beg to differ. This is not the report which is considered. Kindly see the date of this report at page 31. It is 31st October 2019.
Correct.
And the kindly see, whereas RD with a letter dated 11 June 2021. This is not the report.
is a letter. That is a letter. Might be the letter consists of the report. So
No, my lord,
letter-
that
I can't see. Whereas RD here letter so and so submitted a proposal for
kindly,
investigation.
my lord, then the department, if the department says that this is the letter or this has this report, they should have produced the report. There is no such report of this date. My lord, kindly see that he uses the term proposal and not report. These are two different things, my lord. Report is the statutory document under section 208. Inspection report. Report and proposal cannot be treated as the same. And on the basis of this report, my lord, my learned friend showed your lordship page, the winding up petitions. Kindly see the winding up petitions once, please, which my learned friend showed your lordship. It will be very clear, my lord. Kindly see the winding up petition starts at page 54. Kindly see page 54.
Yes.
This is where the petition starts. Now kindly see page 57, which is the synopsis filed by my learned friend's client. May I just place 57, please, my lord? This is their document. They have filed this before the NCLT. The ministry, kindly see, ministry with a letter dated so-and-so has exercised its power and directed the directorate to Directorate Eastern Region to conduct inspection under 2065. This is what my learned friend told your lordship, my lord. Inspection under 2065 of the company Ayushman on the basis of PMOID so-and-so, so-and-so. Then kindly see, accordingly, your lordship has that according.
Yes, continue.
According, the directorate has conducted inspection and submitted its report to the ministry. So this is that 208 report which your lordship saw at page 31, wherein the Ministry of Corporate Affairs, after examining the inspection report, directed the Directorate Eastern Region to authorize the Register of Companies West Bengal to file winding up petition before Honorable NC under section 271C, read with 271D of the Companies Act. In this regard, the petitioner as so and so have issued these directions, and therefore the winding up petition. So, my lord, acting on the basis of the report, which is at page 18, the action has already been taken. Winding up petition filed. 2065 inspection happened. That is what my learned friend also says. Then 208 inspection report came, which is the document at page 31. On the basis of the inspection report at page 31, the ministry directed filing a winding up petition.
Yes.
So, Mala, the full cycle has turned. They have accepted the report at 208, that inspection report. Acting on the inspection report, they direct filing a winding up. Where is now the question of coming to 210 is what I ask myself. And kindly again come to 18, my lord. Kindly do not equate proposal with inspection report. The proposal is, the word proposal does not find mention in this entire chapter 14. They have acted on a proposal which is absolutely illegal. That is why I said you have to act on an inspection report, not a proposal. The directorate, the regional director, Eastern Region has no authority to give a proposal. And even if he gives such a proposal, that cannot form the basis of an investigation under 210. 210 does not say proposal. It has to be a report or under 208. This proposal is not to be found in 210. And that is why the reliance on Taylor versus Taylor.
Yes, next.
Next point, my lord, kindly see. Now, your lordship has seen what the synopsis is of the winding up petition, how the report of the central government, how the 208 report has been acted upon. Winding up petition is filed. Now, my learned friend shows your lordship, my lord, all these transactions which are there, which the central government has complained of.
Yes.
Now, your lordship will go through this entire winding up petition. I am not troubling your lordship with this petition, which runs into 14 pages. But your lordship will go through it, and I have gone through all the winding up petitions which have been filed. There is not one allegation of fraud.
Yes.
There is not one allegation of fraud. When my learned friend is trying to create allegation of fraud in thin air, his petition does not talk of it.
Okay. Next.
Third is, my lord, he relies on the Supreme Court judgment. May I just show your lordship the Supreme Court judgment which he has relied on?
Yes.
Kindly have paragraph 2, please, my lord. This arose from, can you see, High Court is seized of a batch, your lordship has that?
Yes.
Seized of a batch challenging legality of orders of the Union Ministry authorizing an investigation under the provisions of section 212 and 219 of the Companies Act. Now kindly have 212, 219, please.
Where from you're reading?
My lord, these appeals arise from
No,
the Supreme Court decision which he cited, my lord.
Like 22-9.
Sara Housing, serious fraud investing.
Paragraph?
Kindly give me a minute, my lord. The paragraph beginning, these appeals arise from, my lord, has he handed over an SCC copy or an SCC online copy?
Yes, continue.
These appeals arise from so and so, the court is seized. Kindly see the authorizing an investigation under the provisions of 212 and 219. Your lordship has that?
Yes.
So now kindly see 212, please, my lord. Because we are concerned with 210, not 212.
212 is the, yes.
Without so this is without prejudice to 210. This is above and beyond 210. This is an alternative to 210. Without prejudice to the provisions of section 210.
Correct.
So this is, my lord, an alternative to 210.
Yes.
Then central government is of the opinion that it is necessary to investigate into the affairs of the company by the SFIO. Then now, my lord, there are 4 ingredients listed on the basis of these reports. This also has a 208 report. Now, what was the issue before the Honorable High Court? And what was argued? Kindly see the arguments of the Solicitor General. What was the issue? That this was not the issue before the Supreme Court, that you can direct investigation without the ingredients of ABC.
Yes. Next. Yes, anything further?
I think Mr. Thakkar has got muted.
Unmute, Mr. Thakkar. Hey.
I'm so sorry, man. My lord, before the Supreme Court in this decision, the existence of material to form an opinion was not in question. Whereas this is the question before your lordship, 208, the report is silent on investigation. The ABCD, whether ABCD are there or not in question.
Yes.
That is why, my lord, this judgment is of no help, because my primary argument is that there should be material to form an opinion, not on what the opinion itself is.
Yes. Next.
Now, my lord, that is one. Number 2, my lord, in this case, the opinion was disclosed. The High Court said the opinion doesn't give sufficient reasons. Before your lordship, my lord, the opinion is not disclosed.
Correct.
Before your lordship, the opinion is not disclosed. It is only the order based on the opinion which is disclosed. Affidavits were given. No affidavit filed in more than 2 years now.
Yes.
So whether there has been any opinion or not also, my lord, we do not know. It is just an order.
Yes. That's all.
And my lord, one more thing I want to show your lordship, my lord. kindly have my compilation which I've shown your lordship. The compilation which I placed before your lordship the other day, then with all the judgments which are there.
Yes.
The judgment, Bombay High Court Division Bench, kindly see my paragraph, page 27 starts at page 27.
Yes.
Kindly come to paragraph 48. And 47. Section 210, your lordship sees, this was on 210.
Yes.
Now 210 is noticed. Then I'm troubling neck, not troubling lordship, then can you see now 48?
Yes.
Can you see the third paragraph, the central government? Your lordship has that.
Yes.
The central government in the order under challenge did not spell out any circumstances except outlining its power under the above sections to order investigation into the affairs of a company in public interest. This is what they have done in this case also. None disputes that power or its existence. In paragraph 2 of the impugned order, however, a reference is made to the report of the Registrar of Companies West Bengal dated so-and-so, which is not there in our case. We have already held that the findings in this report are not enough for the central government to exercise the drastic power. Something more was required and to be established as circumstances or material enough for exercise of the power. That is clearly lacking in this case.
Okay.
This is the only base. So, my lord, here we do not even have a report under 2081. It is only a proposal. The proposal is not an ingredient under 208.
Okay.
And the Supreme Court decision which I had shown your lordship says the same thing. Kindly see page 56 once, please, madam. There has to be material to form the opinion, my lord. Here there is no material for formation of opinion.
Yes.
And this is a larger bench decision, my lord. Kindly see paragraph 20 at page 68.
Yes, you have to point out. I take a note of it. Page 68.
Yes. So these are my submissions. There is no material to form an opinion. Not that the opinion is under challenge. Bombay High Court opinion was also not there.
Yes. That's what.
Those are my respectful submissions.
Thank you.
Yes, my lord, one judgment of Rohtas Chemicals, my lord, is recorded, but it's not shown. Kindly only make a note of paragraph 6 of Rohtas, please, my lord. May I just hand over? It is referred to in the notes. Paragraph 6 of this decision, please, my lord.
So the block cannot be set back now after referring to the winding up and initiating complaint that they will again regain.
Well, only two sentences I'll say. Well, initiation of proceeding for winding up has no relevance to investigate the matter. Here, 186 sale companies are there. 186 sale companies.
But the report does not say anything on that.
Even if your lordship kindly have a look, once 201, 208.
Yes.
208 says, may, if report may necessary to include recommendation.
Correct.
So, central government is not bound by the report.
But
it is in public interest also, central government can exercise the power.
The company who stated that winding up, you went to the winding up. Where is the fraud on that report?
No, fraud and all these things are there. Your lordship can consider the report on the basis of report as well as in public interest. The central government is forming an opinion on the basis of the public interest also. Now, 208 says, even if a report gives recommendation, there is not also binding on the central government. Even if recommendation is there, central government may not proceed for investigation. And only one thing, even if the company is wound up, if your lordship kindly takes one section, that is section 226. Section 226 says, even after winding up, there is nothing to stop investigation. Even if winding up is pending,
That is against the directive.
yes. So, winding up is pending, that does not mean the central government cannot investigate in the affairs. Well, these are my
Thank you.
deeply applied.
Hearing concluded. See you.
But before my lord rises,
Lordship, the interim order is still date, it may be.
Interim order is extended till the final order is.
my lord, with extreme humiliation, my lord, my lord, may I just have another my lord, extreme plight? 69, my lord, junior brother mentioned is a leasehold property, my lord, 10 days notice. Your lordship was pleased to grant leave, keep it on Thursday. My lord was not there. Today mentioned, my lord, he again mentioned before your lordship, kept this matter tomorrow within 5 items. My lord, the people came, they are creating nuisance, said that whatever the honorable court says, my lord, will not allow, just give us the position. My lord, this is the situation right now in the property. We requested that this is a my lord's pleasure. We have again served them notice. The email has also been sent. Previously, my lord, notice was given. The matter is running in the 69, item 69. If only one day just protection, my lord, if my lord is given for today, tomorrow, my lord, hear it on merit, so that we can communicate that my lord has passed. This such a situation
Can be.
only, my lord, item 69, because if I am, my lord, thrown out, my lord, there's the government people.
Okay, issue the notice to the other side. Let us come at 2. I will see to that.
Very well, very well. I'm extremely grateful. Extremely grateful. 69.
Come after lunch. Come after lunch.
After recess.
I shall come at 2 p.m.
number 89 of your lordship's appellate side list, one of the interim order is expiring today. I'm mentioning upon notice. If the matter can be kept in the list and the interim order could be extended for some time. May I hand up the order?
Item number
89.
recorded not. Though the matter is listed as item number 89 in the today's list, but due to paucity of time, the matter could not be taken up for hearing. The counsel for the petition has mentioned the matter praised for extension of the interim order, as the interim order is still today. At the learned counsel for the petitioner, this court finds that the petitioner already enjoying the interim order, but due to paucity of time, matter could not be taken up for hearing. Interim order is extended till 10th of March 2026 or until further order, whichever is earlier. Let the matter remain in the list.
Grateful, my lord. But may I hand up the mentioning slip as well, which has the notice that can be kept in your lordship's records.
Yes, next.
Great.
Call the
Not only, not seek your lordship's kind leave not to mention about it. This matter was mentioned in the morning, not with regard to not our temporary delisting, wherein we had been debarred from participating in all railway tenders. But in respect of this company, your lordship was pleased to pass an interim order and uphold the validity of not the approach to this court, not overturning not the jurisdictional point raised by the railways. But this document was not placed before your lordship. We had got hold of this. Second is the last date for participating in the tender. I leave it to your lordship, not any day tomorrow or day after tomorrow. I mean, or Friday, not if it so comments to your lordship.
One leave to file.
Yes, not leave to file with a short notice and not a day, not when your lordship.
When the last date?
2nd March.
2nd March. Today we are on 24. 26.
But could it be on 20 or 27th minute if it's so comment?
27. 27 within 5 matters.
Grateful to your lordship. Serve courage. Serve courage.
Yes, call the supplementary.
My lord. So, my lord, before my lord calls my lord's list, my lord, with regard to item number 114, your lordship, my lord, this is the last order, my lord. Interim order is expiring today. My lord has passed, my lord, the interim order and extended it. My lord, I've served all the respondents, your lordship, for the service.
Who is for the respondent?
I appear for respondent number 2 and 3, bank.
And I appear for respondent number 1.
There was a talk for settlement, but no, we made a query to
Okay, I am extending the time. Then let the matter remain in the list.
My lord, I have a request prayer, your lordship. If my lord may kindly, my lord, fixes up a date, your lordship.
There is a settlement. There is no settlement.
No, my lord. As far, my lord, my instruction goes, my lord, there is no such settlement has been arrived.
Item number 114 of the today's list, but due to paucity of time, the matter could not be taken up for hearing. Learned counsel for the petition has mentioned the matter upon notice upon the respondent authorities and submit that the interim order is still today and paid for extension of interim order. In view of the submission made by the counsel for the petitioner, the interim order is extended till 12th of March 2026 or until further order, whichever is earlier. Let the matter remain in the list. We'll see to that.
Lord. Grateful.
69. Who is there?
Extremely grateful. Well, upon mentioning, we have given them notice.
Who is for the other side?
My lord, we have given notice for filing.
Today you have given the notice.
My lord, again, my lord, yesterday, my lord, when we, my lord, we again, my lord, served notice for mentioning today. After, my lord, I mentioned, my lord, again, we have given again and, my lord, a notice. These are the copies, my lord. My lord, may kindly turns to, my lord. Renewal.
Yes. What is the prayer in the writ application?
Well, my prayer in the writ application, if your lordship kindly comes to my lord, page 28 onwards, my lord. My lord, by a letter dated, my lord, of February 13, 2026. My lord, they have asked us to, my lord.
Where is that letter? 13 February, where is the letter?
My lord.
13 February?
My lord, that is the last letter, my lord, at volume 2, 173. By a stroke of pen, my lord, they have asked us to vacate the property. This is a property, my lord, which I run for a 21 years under the management.
173.
173. My lord, for today, my lord, I need a very limited protection. Maybe for today or tomorrow, my lord. Tomorrow, lordship has already kept the matter within five items.
Within 10 days, 13 February.
That is why, my lord, Friday, my lord, we got it affirmed on Monday. My lord, the leave was obtained by from your lordship on Tuesday. My lord has fixed in matter on Thursday. And today, my lord, they again, my lord, came to my property. And my lord,
where is the agreement?
My lord. My lord, it is 35 onwards. My lord, may kindly comes to my lord, page 38.
Period of contact and
My lord, kindly see, my lord, the last but one clause, period of contract and extension thereof.
Expiry of proposed contract, that is 21 years.
Yes.
From the
Now, my
date of
lord,
taking.
kindly comes to.
No, 21 years. So when the agreement was entered?
My lord, the agreement was 23rd February 2005.
23rd?
February 2005. My lord, your lordship would be pleased to find it at page 35. At the bottom, my lord, it says, my lord, 21 years from 23rd February 2005.
2005.
My
So 21 years. So
now, my lord, kindly comes.
That is over.
Now, my lord, it was over, my lord, only yesterday. Now, my lord, kindly comes to page 38. My lord, the renewal clause, renewal and extension. Last but one clause. Has the lordship
mutually agreed terms and years.
My lord.
Taking over the said property and may be extended thereafter on mutually agreeable terms and
Now,
conditions.
my lord, within the time, my lord, I have expressed my desire that kindly extend it. And my lord, what happened, my lord, there was a bare land with some foundation structure, my lord, was given to me at Asansol.
So where is the time of notice?
My lord.
There is mentioning of the time of notice. 30 days, anything is mentioned?
Nothing, my lord.
In the agreement for termination or taking possession, where is that? And arbitration clause is there.
No, my lord, arbitration clause there, my lord, I could say, my lord, it only says about me. My lord, there has been no attendance circumstances, my lord. This honorable court has decided, my lord, that word of me, my lord, without having, my lord, any further attendance circumstances does not construe, my lord, to be an arbitration clause, which has subsequently been affirmed, my lord, by the Honorable Supreme Court also. And I had the privilege to appear in this matter, my lord. It is a case of BGM versus ECL. Now, my lord, if your lordship kindly comes to my letter, my lord, appearing at, if my lord may kindly see, my lord, C126, my demand for renewal, 126, where, my lord, I stated the entire fact that I have a possessory right, my lord, a leasehold right over the property. My lord, what the WBIDC, my lord, wants to do, my lord, he made the construction at my cost, at my pocket. It's a huge hotel. I, my lord, have been regularly paying, my lord, the monthly charges, which I had, it says, my lord, MAGR, which I had contracted, my lord. And, my lord, the agreement says that there has been a first 18 months, my lord, there has to be no MAGR. The construction was admittedly made, my lord, after 10 years, my lord, having the lease being, my lord, entered into, that has been an admitted fact. For 10 years, my lord, I could not, my lord, have the commercial exploitation of the property, but they have been, my lord, extracting money in the guise of MAGR, which I have been paying, my lord, along with interest, which they, my lord, unduly charge. Now, my lord, what I say, my lord, in this letter, page 126, my lord may kindly see, my lord, at 129, where, my lord, we have given the entire details, my lord, that how, my lord, this property was being, my
Yes.
lord,
The petitioner has filed the present date application challenging the notice dated 13th February 2026, wherein the Managing Director WB TDCL directed the petitioner and informed the petitioner that no further extension of the management contact between the WBTTDCL and the Hotel Ascensor Inn will be allowed. And directed the petitioner to hand over the key of the property to the manager in charge within 10 days from the date of issuance of the letter. Date of issuance of the letter. Okay. Well, the petitioner says that on 23rd of February 2005, an agreement for management contract of Asansol Tourist Lodge has been entered between the petitioner and the respondents. As per the clause 16 of the said agreement, the period of contract is 21 years from the date of taking over the said property. It is also provided in the said clause that the time period may be extended on mutual consent with the parties. Full stop. The petitioner submit that though the agreement is dated 23rd of February 2005, but actual commercial operation of the property was started only on 5th of May 2013. And as such, the petitioner has suffered severe loss from 2005 to 2013 as the petitioner could not able to run the business for the said period. He further submit that the petitioner has made a detailed representation on January 12, 2026 to the authorities for extension of time of the lease period, but instead of considering the request of the petitioner, have issued the letter rejecting the request of the petitioner on 13th of February 2026 and directed the petitioner to hand over the key within 10 days from the date of issuance. The counsel for the petitioner submitted the petitioner has invested crores of rupees in the property and is running the business in the said property since the year 2013, though the agreement is from 2005, and as such, the petitioner has requested for extension, but without any reason, the respondent authorities have rejected the request of the petitioner. He submit that as yesterday was the last date of the lease period, and now the respondents are threatening the petitioner for taking possession of the property in question at any point of time. And as such, he prayed for an interim order restraining the respondent for taking any action in terms of the letter dated 13 February 2026. At the learned counsel for the petitioner has filed the affidavit of service and the communication which shows that the petitioner has communicated to the respondent with regard to taking of the matter by this court, but none appears on behalf of the respondent. This court find that on 23rd of February 2005, an agreement was entered between the petitioner and the respondents for management of Ascensor Tourist Lodge. It is a specific case of the petitioner, though the agreement was entered on 23rd of February 2005, and the time period is of 21 years, but original operation of the said property was started only on 5th of May 2013. And as such, the petitioner has made a request for extension of the lease period in terms of clause 16 of the agreement, but without any reason, the respondents have rejected the request of the petitioner and directed the petitioner to hand over the key. Considering the above, this court finds that the petitioner is running the business. As per the agreement, the petitioner is in occupation of the property for management of the Asansol Tourist Lodge, and in 2013, the petitioner is running the business for the property, and the letter dated
13th February 2026, wherein the request of the petition was rejected for extension of time is without any reason. And thus this court find that the petitioner has made out a prima facie case and balance of convenience and inconvenience in favor of the petitioner. This court also find that if at this stage an interim order is not passed, there is every apprehension that the respondents will take possession of the property of from the petitioner at any point of time. Accordingly, the respondents, particularly the respondent number, the respondents are restrained from disturbing the possession of the petitioner over the premises in question till 19th of March 2026 or until further order, whichever is earlier. The petition is given liberty to communicate the gist of this order to the respondent authorities, and the respondent authorities are directed to act in accordance with the gist of the order. This is the matter on 19th of March 2023 under the heading urgent motion.
Under the heading? Well, I'm extremely grateful, my lord. My lord has kept the service and the communication through email, my lord, yesterday and today. One indulgence, if may I seek. My lord, may I request with all humbleness, this order may be uploaded, my lord, if so that
it will be uploaded. Let it.
And my lord, also liberty to my AOR, my lord, to communicate the gist of the order. And my extremely good.
That's why I already just you complete. After the correction, it will be uploaded.
And my lord, the interim order till 19th.
19th March.
But it may be little bit extended till 21st. At least, my lord, I can, my lord, if it doesn't appear, my lord, in that event.
23rd.
I'm extremely. And the matter to appear under the same heading, my lord, urgent motion. One. So grateful. Deeply obliged.
Call the extension. Yeah.
I'm for the petitioner.
Who is for the petitioner?
I'm for the petitioner.
Yes.
This is an extension of interim order, Your Lordship. Extension of interim order.
What is the interim order?
The interim order passed in 22nd of November 2024.
22nd November 2024.
Yes, Your Lordship.
And you are enjoying till date. So what is the necessity of continuing with that? 2024. 1 year, 2 years you enjoyed.
No.
Madam Mayor, this has been tagged with other money matters, madam.
Yes.
All these matters are being taken up together. All these matters are appearing from item number
1 to 4.
1 to 4.
4 of the supplementary.
On the same subject.
Yes.
But I appear for the Pollution Control Board. But sporadically, matters have been filed challenging the order passed by the learned National Green Tribunal. Sporadically, your lordships have extended the interim order. Fixed for hearing doesn't.
I'm appearing to the Union of India in item 6, Your Lordship. If the matter could be, I'm not standing in the way for the extension. If it could be fixed next week for hearing, Your Lordship. Because today it was fixed for Lordship, please. Anytime.
Affidavits completed.
In my item 6, affidavits.
Item 6 only a 5.
Your Lordship, in
Only
the
item 5.
daily list, item 6 is also connected. ma'am.
Item 6 is connected.
No. Daily list, item 6.
Madam, may I? Madam, may I? This
That I will call the fixed matter. I will call the fixed.
Madam, item number 6 and 7 and 8.
That I will take. Now, with regard to 1 to 5, all record an order.
1 to 4, the affidavits are not
1
completed.
to 4.
But may I make one submission? But possibly some of the parties may not have completed. So whenever your lordship is fixing, well, in the meantime, if something is remaining, we shall complete it.
The matter is listed in the supplementary list on the prayer made by the counsel for the petitioner. As the interim order is expiring today. For the petition submitted, the interim order is still today, and if the interim order is not extended, then the form of the petition will be revised. At the land counsel for the parties, this court find that the petitioner is enjoying the interim order since the month of November 2024. Accordingly, make it full stop. Who has not fully stopped? It is found that some of the respondents have filed the affidavit in opposition.
No,
Some of the respondents are
Nobody,
not.
Your Lordship.
Nobody has filed.
Nobody has filed any affidavit. Do they have to report?
No, one.
No.
Okay, let the
Affidavit নয়, report file করেছে।
My lord, some confusion is being created, my lord, is
Please the
being.
matter, क्या बोला?
Report file করেছে।
Enjoying
was
the interim
withdrawn.
order since month of October, accordingly
Probably
for the
this
interest
was
of justice, the interim order is extended till 22nd of April 2026 or until further order, whichever is earlier. Let the matter appear on 22nd of April 2026 under the at 2 p.m. under the heading especially fixed matter. Full stop. In the meantime, all the parties are directed. In the meantime, the respondents are directed to file their affidavit in opposition. If not filed within 3 weeks, reply if any they are to be filed within a week thereafter. Direct कर दे 1 week. एक order repetition. Yes, 1 to 4.
My lord, this is the matter where Lordship had initially granted, my lord, an interim protection that my lord, State Commission under the Consumer Protection Act had directed officer in charge to, my lord, take possession of the property. I was representing the third party. In execution, I was being dispossessed. So I had, my lord, mentioned citing urgency. Lordship had given me the interim protection. Thereafter, my lord, in the interregnum, since it was expiring, we mentioned the matter before, my lord, the coordinate bench. This is the order, my lord.
Yes,
it was, Lordship has it. My lord, it was a limited extension expiring, my lord, today.
Yes.
And my lord, I have, my lord, again, my lord, emailed them, my lord, about this, my lord, matter being mentioned today.
The matter is listed as to be mentioned. The matter is listed as to be mentioned in the supplementary list on the prayer of the petitioner for extension of interim order. It is submitted that by an order dated 22nd of January 2026, this court has passed an interim order and the same was extended till today. Accordingly, he prays for extension of the interim order. He has handed over the document showing the service of notice upon the respondents, but none appears on behalf of the respondents. Accordingly, interim order is extended till it is not in the list.
My lord, it was supposed to be, but it is not.
Till 19th of March 2026 or until further order, whichever is earlier. Let the matter appear on 12th of March 2026.
I'll again inform them.
Under the same heading. The petition is directed to inform the next date of hearing to the respondents and to file the affidavit of service on the next date. Next.
May please, Your Lordship. That I'm led by Dr. Murlidhar, who's possibly there online. We had finished our submissions on the last date. State is supposed to respond today.
Yes, state, who is appearing? Mr. Sen was there, no?
Yes, so Mr. Chatterjee. Mr. Nilotpal Chatterjee was there on the last occasion.
Yes, Mr. Siddiqui and Mr. Chatterjee.
If they have nothing to say, my Lordship.
Yes, Mr. Banerjee, you are appearing.
Item 8. I think item 8.
Matter?
Which matter? 6, 7, and 8. But I'm in 8.
No, but it's.
These are item number 4.
Yes. Probably they have nothing to say. Lordship can reserve the judgment.
Yeah.
The Lordships have given them sufficient indulgence.
Where is Mr. Sen? Can I close the evidence, argument of the estate?
Just now I have seen him. He was actually running to attend any court. Just now, 5 minutes before. I'll make it short possible, but I'll inform.
Okay, Pasu. Or not today?
Not today. Not today.
Come
Keep
tomorrow?
reply to.
It will remain at 2 p.m. tomorrow.
No, not 2 p.m. Then it will be at any time.
Then, my lord, I think perhaps it might be better if it's fixed.
Yeah, a fixed date might suit me also. Because this has to come to an end because I've already made my submissions.
No, there is nothing in this.
Yes.
How you can charge the
Stamp duty of the latest one when the
Let
deed
him
was.
come and save lot better because
May I suggest this, my lords? Your lordships may permit them to file written arguments within a week and reserve orders.
make it not today, Lord, or first over, I can inform him after 8, your lordship can.
Yes, Mr. Sen has come.
Okay. Sorry. আসুন আমি ততক্ষণ সরি মাই আর আমি দেখেছি একটু আগে ছুটে যাচ্ছে
Yes. Well, may I tell today one thing, my lord? Well, I have been briefed in this matter, my lord, just my lord, 2 or 3 days back. May I tell before lordship, my lord, I'm praying for at least 7 days time, my lord, so that I can prepare myself and my lord, no more time I shall.
Point.
I know, my lord, very short point. I have gone through preliminary. Now, my lord,
I think you will not be take much.
my lord. But still, my lord, sometimes I record because of searching something. So, lordship, kindly give me, my lord, 10 days time, because next week I may not be available, but I have to go to my son, Hyderabad. So, lordship,
When you will back?
my lord, 5th, lordship.
You will back.
My lord.
9 या 10 तारीख को टॉप में कुछ है देखो.
Well, it's 10th is all right, my lords.
10th को देखो टॉप में मॉर्निंग 10:30. Ten. टॉप में कुछ है नहीं है. टॉप में रख दो, बाकी देखते जाएंगे. So 10th at the top, urgent.
My lord.
Very well. Well, can it be the final opportunity, my lord, so that they don't take more adjournments?
Now, Mr. Sen told that he will be available.
Yes.
Very well.
Though the matter is specially fixed today at 2 p.m., but the land council appearing for the state press for some time. Accordingly, for the interest of justice, the case is adjourned. Let the matter appear on 10th of March under the heading urgent motion at the top.
I'm obliged.
Or if lordship,
2 p.m. will not. My diary is totally packed till 20 April.
my lord, my top, my get grateful.
Well, your lordships have said top of the list, my lords.
Yes, top of this.
Very well.
Get
Appearing on behalf of the petitioners.
Item number?
5.
Yes.
But I'm appearing on behalf of the petitioners.
Criminal, na? Yes.
Sir, I'm
for the petition.
I'm appearing for case.
But lower court record, this trial court record has not come.
Date be fixed.
Well, this is in effect an appeal. Perhaps the in effect an appeal. Perhaps the trial court records will be required, my lord.
Yeah, that's why I'm asking, because on
Because, my lord, the depositions as well as the
all the thing has to be gone. Due to non-availability of the trial court record, it is not possible for this court to take the matter today. According cases adjourned, the department is directed to take appropriate step to call for the record by the next date fix. Ki date ki hobe? April. Time. Because criminal appeal, it is take time. 23rd February, April. 23rd, 23rd April at 2 p.m.
Well, maybe please to extend the interim order, my lord.
Interim order is extended till the next date of hearing.
Next date. No, 23rd of April.
Interim order is extended.
23rd of April at 2.
बोला ना 23rd April at 2 p.m. as a specially fixed matter.
I'm for KMC one.
Give the name.
Interim order.
Next.
Interim order till next date.
6 to 8. Milord, in 7, Milord, I am appearing for the petitioner led by Mr. Soptang Subasu. Milord, your lordship has today passed an order in supplementary list item 1 to 4
it's a similar, same matters, my lord. Bunch of writ petitions has been filed, my lord. My lord,
Item 8 is
that your lordship has fixed that matter on 2nd of April, and the interim order already passed has been extended.
2nd April.
2nd April.
Which matter?
1 to 4. Supplementary list today.
Not 2nd of 22nd of
22nd.
Interim order till 22nd April. So, Miller, similar order may be passed, and all these matters may be tagged together. Miller, same cause of action, same.
Only item 8, not for the first time it is appearing.
Let me. Who is appearing for the 6? You are for the petitioner. Petitioner. Which for the respondent? Item number 6.
I have filed my affidavit.
So what you are filing? Of the all. Record an order. Item number 6. Item number 6. Item number 6. लेकिन एक ही में जाएगा. Item number 6. It is submitted that all the respondents have filed their affidavit in opposition after serving the copy to the London Council for the petitioner. The petitioner has filed the affidavit in reply to the affidavit in opposition of the respondent number 1, 10, 11, and 12. Let the same be kept with the record. It is submitted that the connected matters are fixed on 22nd of April 2026 at 2 p.m. Let this matter be appear on 22nd of April 2026 at 2 p.m. Interim order is extended till the next date of hearing or until further order, whichever is earlier. And what about the 7?
7.
Milord, in item number 7, Milord, I appear for the petitioner, Milord. In this matter, Milord, we have not received the opposition from the Union of India as well as the Central Pollution Control Board. In spite of there was a direction on several occasions that, Milord, unless they come with the affidavit, Milord, the matter cannot be decided on.
Which for the Union of India? File. File लिखो नहीं.
Actually,
Lordship,
may I appraise your lordship what has happened? Milord, on today the interim order was going to expire, Milord. And since your lordship was not sitting on Thursday, Friday, so we mentioned the matter yesterday, Milord. The matter was your lordship's determination was being taken up by Justice
Bhattacharya.
Chogoto Bhattacharya. Milord, we mentioned the matter over there. The matter was listed at 2 p.m. in the supplementary list, Milord, and the interim order has been passed till 31st of March. Now, Milord, today all the bunch of matters are appearing. Milord, what I was submitting, Milord, since the similar matter has been fixed by your lordship on 22nd of April, and it is same cause of action, same, only petitioners are different, challenging the same impugn notices. Milord, let this matter be tagged with that.
And what about the 8?
8, I am for the petitioner. Coming up for the first time, I have served, Milord. In this paragraph, no direction or affidavit has been passed because for the first time it is coming. Let them use the affidavit.
Record an order 7. Item number 7.
Tag to Quran already.
We have not received the
item number 7. It is
It
submitted to the council for the petitioner that the matter was mentioned before His Lordship Justice Sugato Bhattacharya on 20th of February 2026, and the interim order was extended till 31st of March 2026. He submits that you file the affidavit. Have you served? You are appearing for?
Milord, we have not been served with a copy till date.
The petitioner submits that none of the respondents have filed the affidavit in opposition. Learned counsel appearing for the pollution control.
No.
Central Pollution Control Board.
আমাদের চেম্বারে যেটা
That
হবে
they
না
have filed the affidavit in opposition after serving the copy to the Land Council for the
ক্লার্কের চাকরি চলে যাবে
in view of the above, the respondents who have not filed the affidavit in opposition in the present matter are at liberty to file their affidavit in opposition within 3 weeks from date. Reply, if any, they are to be filed within 2 weeks thereafter. List the matter on 22nd of April 2026 at 2 p.m. as a specially fixed matter. interim order, which is already in existence till 31st of March 2026, extended till 22nd of April 2026 or until further order, whichever is earlier. Okay. 8 2 is appearing.
I am for the petitioner, my lord. But I have
Yeah.
served everybody, my lord.
8 Learned counsel appearing for the petitioner has filed affidavit of service. Let the same be kept with the record. So and so appearing for the state. Full stop. It submit that there is no order. There is no direction for filing affidavit. In view of the above, the respondents are directed to file their affidavit in opposition within 3 weeks. Reply, if any, thereto, filed within 2 weeks thereafter. List the matter.
Interim
On
order
22nd.
passed in this matter also, same interim order, because other.
22nd of August, 22nd of April 2026 or until further order, whichever is earlier. Interim order is extended till the next date of hearing.
No, today it is passed, my lord. For the first time it is appearing, so interim order.
Interim order is not there.
First time it is coming. First time it is coming. Your lordship has tagged the matter with the other matters. Lord, I am praying for same relief. Same order is under challenge. Same interim order. Same notice. All the matters your lordship has passed the interim order.
By 22nd April, lordship will find more hotels coming in.
Stay of the notice, my lord.
Come on that day.
Lord,
what is the interim order?
Interim order is stay of the notice, my lord, prayer rail, as per prayer rail. That has been passed by your lordship.
Petitioner has prayed for an interim order. This court finds that in the above matters, there is already an interim order. Accordingly, the respondents are restrained from taking any action in terms of the notice dated
11th November 2024.
11 November 2020.
24.
2024 till 22nd of April 2026 or until further order, whichever is next.
I appear for the.
And I am appearing for the petitioner, my lord.
Lord, I appear for the respondent number 2 and 3.
My lord, the affidavits are complete, my lord.
Lord, today it was fixed, my lord. We had mentioned earlier, your lordship remembers, Mr. Abhrojit Mitra is leading us. Mr. Abhrojit Mitra, my lord, he has suffered a bereavement in his family. That is why I'm praying, my lord.
And it's a bit, my lord, embarrassing, but my lord, may I just put it this way, my lord? My lord, Mr. Mitra's client is the second client, my lord, as in the main respondent should be the RBI, my lord, who has refused my prayer for putting this company into insolvency because they have not paid. Now, my challenge is the RBI has not disposed of with my application after taking into contention whatever my case was. The reports have all been filed, exceptions are over. But I do understand, my lord, in your lordship's case, my lordship's dates are, my lord, somewhere from 20th of April, my lord. My lord, that is the point, my lord. Your lordship, my lord, if the adjournment is today granted, my lord.
Which vacation?
After the summer vacation?
My lord, my client is in very, my lord, I wouldn't have said this, but since it's Mr. Mitra, my lord, I have my own limitations also. My lord, so, my lord, I'm a bit confused. If your lordship can.
So what do you want? What do you want?
My lord, I would love to do the matter, but my lord, it's a case for bereavement, my lord. That is why, my lord, I've got instructions to. But if your lordship can give me some date, my
So the
lord.
matter is specially fixed today for hearing at 2 p.m., but due to some personal difficulty, the advocate appearing for the respondent number 2. The case is adjourned. Let the matter appear on 19th March within 5 matters.
But I'm very grateful. I'm very grateful, my lord.
Urgent motion.
Lord, just
I'm
to,
very grateful.
Lord, 19th will, Lord, is an uncertainty because 19th, Lord, may be Eid. It can be. Because otherwise, most probably.
Then 24th.
My lord, I am representing Reserve Bank of India in the matter. Today in the morning, I served a copy of an exception to the report which was filed by my client. And along with that, a supplementary affidavit. From the tenor of the both the affidavits, what I find is the primary answering respondent has now become RBI. I would require assistance from my client. So I was beseeching your lordship if your lordship would consider granting me some more time so that I can come back with instructions.
24th March.
24th March.
24th March within 5 matters under the urgent motion.
Very grateful, man. Very grateful, man.
2 exceptions and 1 supplement.
The exceptions and
And one
supplementary
One
affidavit
supplementary
filed by the petition be kept with the record.
In the meanwhile, if I require to file anything, may
So
I be
the Reserve
permitted to
Bank of
file
India has
that
liberty to take to file a rejoinder to the exception if any in the meantime.
in the meanwhile? I shall.
All the parties. If we also want to file, we'll file it.
In the meantime, any of the parties want to file rejoinder to the exception. In the meantime, any of the parties intend to file rejoinder to the exception may be filed in the meantime.
Grateful.
Deeply.
Very grateful, grateful.
Next. Item.
I beg to appear, my lord's direction was, my lord will kindly recapitulate is that not more than 30 seconds, my lord. My lord will kindly, there was a bereavement in my family, my lord. So, my lord, I could not prepare my reply. So, my lord will kindly extend it by 1 week only, my lord, and my lord will keep it for you.
Appear for the private.
What is it, sir?
1 week.
1 week, my lord will allow this.
Reply.
Yes, lord. Reply.
May I have the liberty to file the opposition?
Opposition. Affidavit in opposition filed by the petitioner be kept with the record.
Opposition
filed by the respondent number 3 and 4. Be kept with 3 to 5. Be kept with the record. Learned counsel for the petitioner press for extension of time to file reply. Let the reply be filed within a week.
Lordship.
Within a week. List the matter on 10th March.
I'm grateful, Lord.
Under the same heading. Next.
My lord.
I'm appealing for respondent number 3, my lord.
I am for the petitioner. Lord, it is that matter your lordships earlier in a writ petition heard this matter as regards to the my lord updatation of Aadhaar card of a minor, my lord. Your lordships order is at page 28, my lord. Kindly comes to your lordships order first, my lord. This is my affidavit of service. My lord, your lordship directed the UDI authority, my lord, Aadhaar Identification Authority, to my lord consider the application of the my lord petitioner for correction of the name of the minor, my lord.
Respondent number 2 is directed to consider the application submitted by the petitioner along with the above mentioned document and to pass appropriate order.
My lord.
Yes. Then what has happened?
The authority has passed an order, my lord, without considering your lordship's observation as regards to the my lord gazette notification. My lord, I have shown to your lordships on the last occasion when your lordships passed the order that in case of a my lord West Bengal gazette notification, a minor cannot apply for gazette notification. But I have also annexed this gazette, my lord, in my writ petition also, my lord.
Where is the order? Where is the impugn order?
My lord, impugn order is at page, my lord, 34.
34.
34. In the same line, they have, my lord, rejected that gazette notification is required. Otherwise, they cannot, my lord, update. My lord, point number 2, my lord, last 2 lines, my lord. List of documents approved by UDI for major name change, gazette notification is required.
The document that is the caste certificate is not a valid document for major change as per the list of documents approved by data. For the major change, gazette notification is required.
Yes, sir.
Although the mentioned order, the state government do not have the provision for name change of a minor resident through a gazette notification. However, guidelines and the procedure for the same is already in place as mentioned by the publication minister itna, and the same is attached here with. And where is attached? Huh? Where is that?
My lord, gazette notification. My lord, I have
same is
annexed
attached here with.
page 39. Kindly come. Page 39. 39. And your lordships in your earlier order, my lord, specifically observed considering all the documents of the minor, my lord.
Who can applicant? Yes. Then.
Therefore, my lord, I cannot.
Which portion?
My lord, 2, my lord. Point number 2.
Who can apply?
Yes. Who can apply?
Can be application.
Yes.
Attaining the age of 18.
Attaining the age of 18 years
and
above, who is the domicile of West Bengal. So this is in my case. Next part is otherwise. And in respect of bar council, that is, my lord, I am not interested. The first part is a person attaining the age of 18 years and above, who is the domicile.
No,
and fact remained is this, my lord.
No, they are telling that the enclosed, which enclosed? The attached here with your kind perusal. What is the attachment they are relying upon?
My lord, page 35, it starts from page 35 as regards to the guidelines for change of name of minor. My lord, here also, my lord, point number 1. My lord, the individual concerned, that is either father or mother, has to notify the change of name of his or her minor son and daughter. Is one of the daily leading newspaper, giving their in full identification of the applicant, father's name, husband's name, along with residential address, the
Page
of
of
the
the
child,
child.
the full page of the newspaper containing the aforesaid notification should be submitted in the report.
I appear for the, I am challenging. But as per the minor and act, the grandfather cannot be the guardian. The guardian has to be the natural guardian. So for that, in that case, Dr. Saini comes to paragraph 1. The father is missing since 2011. Without the authority from the competent court appointing the grandfather as the guardian, that cannot be the mental ability point. Structure can be kept open.
And this is a very unfortunate situation, my lord.
No.
My lord, so far, my lord, what is happening in this case? My lord, kindly, my lord, allow me for a moment. My lord, Agni, madam. My lord, petitioner before lordship is the minor. My lord, admittedly, he is a minor. He is attained majority in the month of August 2026. My lord, this year. My lord. Now, my lord, so far the examination party is concerned, my lord, NTA has published a notification. If there are irregularities in the Aadhaar documents, it has to be rectified. Otherwise, the candidate cannot apply for, my lord, NEET examinations. My lord, that is the notification. That's why in the first date petition, I have challenged, since I have applied for the Aadhaar correction before the Aadhaar authority, my lord. Since I am a minor, I cannot, my lord, apply. Since I don't have any father and mother, my lord, being a legal guardian, he cannot, my lord, grandfather cannot apply for, my lord, the change of name, my lord. That is the gadget notifications, my lord. Now, at this stage, where a minor student will go, my lord, well, kindly consider these aspects, my lord. My lord, all the documents supports that I am a, my lord, Ovirup Kundu, my lord.
I am
But
telling-
other, my
see,
lord.
what is the problem with all of you? You only knows the writ petition. Yes, anything has happened, go 226. You don't know the pros and cons. If a minor is there, father is missing, mother is unfortunately mother is not aware. Mother is
also missing.
Mother is not. Mother is missing.
Yes.
So what is the recourse you have to take?
My lord, that is there, my lord, 106 Evidence Act, my lord.
What evidence?
As regards to the death of, my lord,
you have to go to the guardians and you file an application for guardianship.
My lord, it will take, my lord, more.
What take? 2 minutes.
My lord, that
file an application under section 12(7) and file an application interim application under section 12. You get an order of the interim order, and you will get.
My lord, that is true, my lord. My lord,
half an hour.
My lord, so far the, my lord, rectification, my lord, being a minor, my lord, it is not my fault, my lord. My lord, kindly consider these aspects, my lord. It has to be applied by the guardian. My lord, I being a minor, my lord, I am unable to participate in the selection process, my lord. My lord, kindly consider all. My lord, all the documents.
Today, if suppose today the court allowed, and tomorrow the mother or father came in picture, who will take the responsibility?
My lord, so far the name is concerned.
Whatever it may be, name, age, whatever it may be.
My lord, all the documents supports. But I have annexed all the documents.
That is not the thing. Tomorrow, if the mother and father came in picture, and they will deny they will take. Who will take the responsibility?
My lord, so far the, my lord, educational qualification. So far the educational qualification, caste certificate, domicile, everything in the name of.
When is the this NEET application last date?
Well, last date 8 March. That's why, my lord, I took.
I'm appealing for the response number 3 NEET authority. My lord, we have a specific instruction. My lord, kindly comes to page number 43 of the writ petition.
I have annexed everything. I have annexed.
Clearly says, my lord, that it should be in the consonance with the Aadhaar card, my lord. His domicile certificate and in his birth class certificate, OBC certificate name is something else and Aadhaar card name is something else. So until that is not changed, we cannot, my lord. That is the instruction, my lord.
What?
My lord, kindly see page 43. It says, my lord, Aadhaar card. My lord can see A, Aadhaar card.
All candidates appearing in TA.
NT are advised to ensure that the Aadhaar card is accurate, valid. Now, my lord, in Aadhaar card only his name is different, my lord. Till the time that is not rectified or changed, we cannot do anything, my lord.
In the birth certificate, my name is appearing, my lord. Ovirup,
So
alias Supradeep, my lord. domicile
You do
also.
one thing, you take instruction.
Very
For the time being, let this petitioner maybe allowed to appear in the examination. Correct. Appear in the examination. And I will allow you withdraw this petition, go to the district judge, take an interim order, take an interim order and file the application before the gazette notification and do that. Nothing.
Yes, my lord. That I will do, my lord. My lord, what is following? But kindly direct my lord NT also
Yes, my lord.
to allow
That's why
as an interim
you-
measure.
That direction,
you take
instruction. Yes,
instruction.
ma'am. I'll have
I
to
am
come back with
keeping day
instruction.
after tomorrow.
Very well.
For the temporary measure,
Very well.
let the NIT authority allow to participate on this name.
Very well.
This name,
I'll
alias so and so, whatever it may be, and the final decision will be taken when the gazette notice. There is a dispute of the mother father.
yes,
It's a
yes. That's
unfortunate,
very unfortunate.
unfortunate child. Correct. And I will give the liberty. You go file an application
that
before
I-
the district
that I
judge,
do.
take the guardianship
Yes,
and
that
got
I
an interim order and you got it.
That I will do, my lord.
Very well.
My lord, I was appearing with Mr. Chakravarti, my lord. My lord, as far as NT is concerned, my lord, there is some difficulty, practical difficulty also.
That's
Not-
why
yes,
please
yes,
check. Please
yes,
check if it is
yes,
possible.
yes,
If
yes.
it is
We
not-
want to help the child, but the difficulties are there. That is the.
Given one day
Yes.
time so that you
Yes.
can consult with the
Lord-
authority. What
Lordship.
would be the option?
Because it has to be uploaded, then it has to be, applied online. So
Correct.
there will be some mismatch and all these things. There will be some difficulty later on.
Okay, you take instruction.
We'll take instruction.
If any option is there, then it can be done.
Very well. Lordship.
The respondent number.
Respond number 3, my lord.
Respondent number 3 is directed to take instruction whether the petitioner can be allowed to appear in the NIT examination with the old name, pending the correction of the name by way of gazette notification. Let the matter appear day after tomorrow. Kya date hai? On 26th, under the same head.
Yes, ma'am.
The report filed by the state be kept with the record. The London advocate appearing for the 2 and 4 raise the point of magnitude. The same is kept open.
My lord, I may not be available, but Mr. Chakravarti will be there.
Yes, my lord. I'll
Deeply obliged.
put to the net.
My lord, can it be at any fixed time, my lord? So can it be at any fixed time, my lord?
9th.
But day after tomorrow, my lord, at any time, my lord.
No, urgent motion, it will come up.
My lord, within 5, then, my lord. My lord, kindly consider that. My lord,
Within 5 minutes.
my lord.
Within 5 minutes.
My lord, only one indulgence. In case the director, my lord, wants to, my lord, make submission, because they can explain in a better, difficulties, practical. So if your lordship kindly allows, subject to your lordship's, my lord, permission, lord.
Okay.
He will be appearing from Delhi, my lord.
Okay. No problem.
Because this is a very peculiar case, and the lordship.
That's why I given chance. Let the
My lord.
Otherwise, I let then the order of the court will see what is to be.
Very, lordship.
Life of a student. Yeah.
Yes.
Grateful, lord.
Your lordship need not open the brief, kindly hear me 2 minutes time. Need not open the brief, kindly hear me 2 minutes time. The petitioner was appointed as a Muslim marriage register in Kagdi police station permanently. Number of the post is also permanent. Now, by virtue of the gazette notification, I was appointed as a permanently. Page 20 of the notification, kindly see. Page 21.
Nasruddin Badya.
Yes, the government.
Lordship.
Hereby to appoint the person named in column 1, kindly see column 1, Muhammad
Correct.
Nasruddin Baidya. And the police station, kindly see column 2, Kagdi PS.
Yes.
Column 2. But this was the gazette notification for permanent post. Now, thereafter, my lord, I made a prayer for transfer from Kagdi to Golaghat police station. But that order was for page 34. Page 34.
Yes.
The understand furnishes here with the reason order dated such and such on the subject noted above for information and according necessary approval of the transfer of the area of work. I didn't know that. So Dhola police station entire area of work has been entrusted upon me to do the work as a Muslim marriage register. Now, my lord, kindly see page 21.
The undersigned finishes here with a reason order and subject noted information and necessary approval for transfer.
The area of the work of Muhammad Nasruddin Boito as
From
Muslim
Kakdeep
marriage
to
register from Kakdeep police station to Dholaghat police station.
Dholaghat, yes.
So therefore, under the area of Dhola police station, all area have been entrusted upon me to do the work as an MMR.
Correct.
Now kindly see page 21A.
Yes.
Therefore, the honor and license has been given to me by virtue of the section 2 of the Kaji Act,
Correct.
1880.
Correct.
Now, what happened in the meanwhile?
Kaji Act.
Kaji Act 1976.
Then?
Now, what happened? I came to understand that one person has applied for a temporary MMR in respect of the Dhola police station. I immediately made an application. My page 60.
Sir, the page 21A. You are satisfied with this order?
No, this is license. Only to do the work. Only to do the work. This is license to do the work permanent.
Correct.
Yes.
Petitioner is appointed as both Qazi and Muslim marriage.
That's why I'm asking. So this is the Qazi.
Yes.
This is the Qazi with regard to which area? Dholaghat. Dholaghat.
Yes. Dholaghat.
So
now, my lord, thereafter I came to understand that one private person made an application in respect of that police station for being appointed as MMR temporarily. Now, I made an application immediately, page 60.
Page?
60.
60.
And I am reading that application. And you also got it. I beg to state that I am the permanently appointed Mohammedan marriage registrar and Qazi of Dhola police station, duly appointed as per government notification, which mandates that only one permanent MMR oblique Qazi for each police station. I have been discharging my duty sincerely and continuously in the permanent post of Dhola police station. It has come to my notice that one individual has recently submitted a prayer to the department seeking appointment as an
now what is the problem?
Now problem, my lord, what happened? Page 49, kindly see page 49.
Yes.
What they have done, my area has been curtailed. But I am reading that. Kindly see. By virtue of the authority confirmed by section 3 of the Bengal Mohammedan Marriage and Divorce Registration Act 1876, the government is pleased to withdraw you to register and in the manner prescribed by the above act, all Mohammedan marriage and divorce which shall be effected within Dholaghat police station comprising the territorial area over parts of the Kakdeep and Kulpi Dholaghat police station in the district of, therefore area has been limited. We have been given the entire area in respect of Dholaghat police station. Now the limits has been given because with the purpose to give the temporary appointment in that particular fellow. Now, my lord, this was challenged before this. Now, my lord, immediately what happened?
Your Lordship, Mrs. Jhuma Chakraborty is appearing for state, Your Lordship. Mrs. Jhuma Chakraborty is appearing for state, Your Lordship. She is in court number 16, Your Lordship.
Yes.
I will go. I will go and sit at court number 16.
A license had been annexed. Enough. Kindly see the license. Without following any procedure. Suddenly a temporary appointment has been given. We shall be affected Dholaghat PS area comprising the territorial limits over the parts of the Mathurapur, one.
Tell me
and-
one thing.
Huh?
Tell me one thing. If you are doing some area, what is your remuneration? It's a permanent payment or whatever it is.
No, this is not any remuneration.
There's no remuneration. So
No.
why you are so agitating if the another person is been appointed?
Because I have the threefold submission. I have the threefold submission. First submission is that when there is a vacancy of permanent, when I've been appointed permanently by virtue of the gazette notification, a person without due process of law cannot have any entry to work by curtailing my area.
Show me how many marriage officers can be appointed in one area.
My lord?
Show me the law that only one marriage
Yes,
officer
yes,
is to
yes,
be
yes,
appointed, no further marriage officer is to be appointed. Where is
Yes.
the law?
Yes, I'm giving that. Please. I brought this notification. In respect of one police station, one MMR.
Show me.
I'm giving that. What is the notification, sir? Kindly see. Kindly see.
What is the limit that is mentioned in of 1979?
In respect of Sunni community.
Yes.
The jurisdiction of the Muslim as registered Sunni community shall be for one or more police station of the district West Bengal as the government may determine. Therefore, I can be for one and more. But two more register can be appointed in respect to one police station. And moreover, this is temporary appointment. Now kindly see the rules first. Kindly see the rules first. Certainly a license is given to a particular fellow who will be make an entry in my area. Kindly see rules 3B. 3A permanent, there are two procedures. 3A permanent, 3B temporary. He has been given temporary. Procedure in making the temporary appointment. In making temporary appointments, the permanent committee need not be consulted. The district registrar shall nominate a suitable person for his vacancy. The district registrar's nomination shall be submitted to the government by the Inspector General Registration, who, if he disapproves the district registrar nominee, may recommend the appointment of other candidate. Temporary license shall be given. Therefore, what is the recommendation? What is the list of recommendation? What is the letter to be forwarded to the secretary? What is the appointment letter? Nothing of this sort. Statewide license is given. This is total backdoor process. And Supreme Court has said, when there is a permanent, I have bought this book. Supreme Court said, when there is a permanent post, when there is a vacancy and the permanent post has been filled up, the temporary appointment cannot be. Now, you have given entire area in respect of the Dollar police station. I made an application.
Okay, let you file the report. How soon you will file the report?
We have for this date, your lordship.
Yes, you file the report? When?
Within 2 days, your lordship.
2 days?
Yes, your
Sure.
lordship. We have already contacted the law department, your lordship. Within 2 days.
File the report.
Hmm?
The petitioner has challenged the order dated 15th December 2025, wherein the private respondent is appointed as where is the order of appointment? Where is the order?
Nothing of this sort. Only license.
Where is the this one?
But supplementary have announced the license.
No, not that. What you are challenging the writ petition?
Hello?
What you are challenging the writ petition?
Challenge the petition to approval, license, and also by law curtailing area. There's 49 curtailing area and also license.
The grievance of the petition in the present writ application is that The petitioner is appointed as Muslim marriage registrar under the jurisdiction of police station Kakdeep. Subsequently, the petitioner has made a representation for change his place from Kakdeep to Dolahat. And accordingly, your place was changed. Kakdeep to change, it was Dolahat. Where is that order?
Page 34.
Subsequently, the petitioner made a request for changing of his place of work from Kakdeep to Dolahat. Accordingly, by an order dated 15th May 2012, the place of work of the petitioner has been changed from Kakdeep to Dolahat police station. In the meantime, the private respondent has made a request to the corresponding authorities for appointment of temporary marriage registrar. And when the petitioner has came to know that the private respondent has made an application for appointment of a temporary Muslim marriage registrar, the petitioner has submitted an objection to the concerned authority. Full stop. In spite of the objection raised by the petitioner, the respondent authorities have allowed the private respondent to act as a temporary Muslim marriage registrar by curtailing the area of the petitioner. In view of the above, this court find that a report is required to be filed by the state respondent. Accordingly, the state respondent is directed to file report by 2nd of March 2026 after serving the copy to the counsel for the petitioner. The counsel for the petitioner has liberty to take exception to the report if any. Release the matter on 6th of March 2026 under the same heading.
You also pick the matter on 6 March.
Yes.
You also pick this matter 6
March. 6 March. Let them file the report. You give the exception, then we'll fix.
6 March at the top, 6 March. Since you
Urgent motion.
Urgent motion, there are so many matters.
What can be done? You all person are mentioning the matter that will be. If then tomorrow I will take not serially 1, 2, 3, 4 like this. Horizontal, not the vertical.
Let it within 5 matters.
Come, sir. Yes, call the matter.
Yes, my lord, I appear on behalf of the petitioner.
Yes.
Yes, my lord, the
and led by Mr. Colbus.
The affidavits are complete, my lord. Subject to, my lord, it's a case. Razi, ওই পেজটা কোথায়? পেজটা কোথায়? Reply. 23 and 24 are, my lord, analogous matter. কোথায় কাগজটা?
What is the matter?
Yes, my lord. The unfortunate lady, my lord, she, my lord, was a widow. Subsequently, my lord,
Where is the order? P8?
Yes, my lord. P8. I am showing. Page কত?
Where is the P8?
Yes, my lord.
No P8.
No P8 in my
No P8.
No, my lord.
No P8.
May I submit? Here, there are two cases for such reason, my lord. Typographical error at the stage, my lord, when I have moved the motion, my lord, I have indicated before your lordship. Now, my lord, if your lordship kindly sees the first matter, my lord, here, my lord will get that page 19, death certificate of the husband. My lord has got it.
Sir, I am asking where is the impugned order?
My lord, there is no impugned order, my lord. The cancellation is there.
Kindly come to the prayer.
Yes.
Lordship, kindly see
Kindly come
page
to the
number
prayer.
33, Your Lordship.
33.
Page number 33.
33. Page number 33.
Can't be.
Yes.
Can't be.
Yes, my lord, if you
Kindly come to page 39.
page 39.
39.
Oh, yes, my lord, page 39.
39. Thank you.
So I am ready with your view.
No, my lord, I am, my lord.
So that's why you take minimum cases, not the lots of cases. So you cannot be confused in future.
No, my lord. I am confused only because of the reason I should be bona fide to a lordship that I was under the impression the matter will not be taken up because my lord, time shows my lord, there is a reference. For such reason, my lord, I was
Okay, then not today.
not today.
May I then
Tomorrow.
mention, my lord, one
Then-
matter?
Tomorrow I shall raise that original side, your lordship.
My lord, extension of
Get
an
it.
interim order, my lord.
Original is complete.
May I mention that matter, my lord, which was fixed at 8:45. Wipro was appearing. I had a word with him. Said that I had a word, and my lord, he requires, my lord, he said that can it be fixed, my lord, on the week of just after the holy, my lord, from that ninth week.
It is fixed today.
No, all of a sudden, my lord, that date time is gone, my lord, because I think Lord Shu was not there. That is why the officers may have. I had a word with him. He said that I sat with the Chief Justice. Can it be, my lord? He requested me. He was supposed to be. I given him notice. Can
Your
it be-
original side, no.
Original side.
Can it be, my lord, on that week? This is also original side, my lordship remembers. Can it be, my lord, on that week of 9th, my lord? It is appearing today as item number 35 without the time.
9th March.
Yes, that week, my lord.
9th
Just
March.
after Holi. At 3:45, 9th or 10th, whichever.
3:43 p.m.
My lord, I should inform him on 10th.
9th at 3 p.m.
Very
9th April is Monday.
9th March. 9th March at 3 p.m.
It's an original site matter. I'll inform him. Great.
Direct then, huh?
No, my lord, may I?
Inform the other side.
Yes, I had a word with him. He only, my lord, requested me to say it to him. Great.
Don't scold me. Petition, my lord, I am seeking your lordship deep to move a matter, my lord.
What?
Not extremely urgent, my lord. It concerns, my lord, the entire election process. You know, the CCTV cameras and surveillance system, a tender was floated. Basic minimum time last Friday was the, my lord, a corrigendum was issued, and today they are opening it, my lord, the technical bit, they are going to upload it day after tomorrow, and the financial bit is also being opened the day after tomorrow. There are tailor-made conditions all over the country. Only two, my lord, enable one big pair to participate. They have imposed certain conditions, my lord, which technically debar me. My lord, that is the urgency, my lord. May this matter, I'm seeking it leave to file it, my lord. I'm going to serve, my lord, may it appear tomorrow, my lord. Otherwise, I'll be in a dead-ended situation. My lord, in the original side. My lord,
Original
kindly,
side?
in the original side. No, kindly, my lord, I know, my lord, the pressure, my lord, kindly. Pardons me.
Correct.
No, not up.
3 p.m. 4 p.m. ठीक है उसको 3:30 रख दो.
My lord, may I have mention contempt application not so urgent, your lordship. On the last, not so urgent. Your lordship, on the last occasion, your lordship, you were supposed to file your lordship the compliance report. Somehow, your lordship, you are not there. Matter has gone out of the list. Any day, your lordship, after 1 week, 2 weeks, your lordship,
Item
kindly keep
number?
it.
You done now.
My lord, item number 81 of my lord today's list, my lord, original side matter. Interim order was till 19th of February as per your lordship's order. 20th of February is the original side matters when Justice Mithro takes it up. I went on 20th of February to mention because it expired on 19th. My lord Justice Mithro observed that I should come and mention before your lordship. We again tried, my lord, on Monday before the other coordinate bench which had urgent determination. Same reason why, my lord, this was not extended. Now today is the second day after it has expired. My lord, my other side is here.
Difficulty apart from the fact that I'm opposing after the expiry. The difficulty brother, is that what has been stayed is a statutory notice for invocation.
That is on merit.
Personal guarantee. I'm not getting into the merits, but my NCLT proceeding has now been solved completely.
Any day, lordship keeps it any day, my lord. This week also, my lord, I am ready and willing to do it, my lord.
The judgment, my lord, I was looking at it, my lord, that Sanjay Jhunjhunwala judgment. Now it says that a statutory authority, my lord, you go before the NCLT.
My notice has been stayed by.
My lord, this was absolutely different. I am aware of, my lord, that Sanjay Jhunjhunwala matter. This is, my lord, 2014 demand. My lord, in 2025, IBC proceedings are being initiated. It's hopelessly barred by limitation. On that ground, I was, my lord, given this interim order.
Ground of objection is the recess. Apart from the
Reimposition and, my lord, extension. Limited period. Any day lordship wants me to come back and argue, I will.
Item number
81 of today's list, my lord.
I will not take more than 2 minutes by the. I'll only place one judgment and rest my case. I'll not show anything. Any day, my lord, as per my lord's convenience, my lordship.
My lord, immediately after the, my lord.
I will keep fix whenever the 330 resolution.
Position is such, we'll do that also, my lord.
And the matter is listed as item number so
81. my lord.
Counsel for the petition submitted. The interim order was till 19th of February 2026 or until further, whichever is earlier. But on 19th, this court was not in session, and according the petitioner has mentioned the matter before the court having the determination, but the matter could not be taken up for hearing. Accordingly, he pressed for reimposition of the interim order. Learned counsel appearing for the respondents raise objection and submit that due to the interim order passed by this court, the respondents are facing difficulties, and as such he object for reimposition of the interim order. Had the learned counsel for the respective parties produced the order, this court find that the petitioner is enjoying the interim order for the last. Since when?
My lord, the last annexure is the, my lord, order.
August 2015. It is further submitted. The pleadings have been completed. The matter is ready for hearing. In view of the above, for the interest of justice, the interim order is reimposed. Yeah, I could date. What time? Is reimposed till 31st of March until 2nd of April 2026 or until further order, whichever is earlier. List the matter on 31st of March at 3:45 p.m.
Very grateful.
Which number? Not listed. So let it become tomorrow. Has to be mentioned then. Day after tomorrow to be mentioned for withdrawal.
Item number 1 was for fixing of date.
Item number?
We had it before your lordship by getting release from justice. Aniruddha.
I am releasing.
No, your lordship has heard. I'm led
Item
by
number 1, my lord, I appear for the defendants.
What is the matter?
It's an insurance claim. It was a commercial suit. Insurance claim.
My lord had heard it, but my lord had not fixed it as part heard, my lord.
So why it has come here?
My lord, the plaintiff instance, my lord, they prayed for a release before the regular bench, my lord, and they have mentioned it.
Go to the regular bench.
It has already been assigned before lordship because your lordship has heard.
Court is overburdened.
Any date, my lord, as per your lordship's convenience, any date, and I assure your lordship.
Date April में देखो.
Complete my argument.
Item number 2, my lord, for notes of argument, for filing notes of argument. My learned friend is also here.
6th May.
6th of May.
It is submitted by the learned counsel for the parties. The matter is ready for hearing and praying for fixing the matter on a specific date and time. In view of the submission made by the counsel for the parties, let the matter appear on 6th May 2026 at 3 p.m.
Item number 2 was for filing notes on argument. May I find my learned?
Who is filing? Who is the other side?
For the petitioner.
Item number 2. Both the parties have filed their affidavit, filed their written notes of argument. Let the same be cut with the record. CAV.
Grateful.
2nd of March and 9th of March, my lord, for the plaintiff's witness action, madam. And there has been a development on 1st of March, my lord, to undergo surgery.
Okay, note कर लो.
On 9th of March, my lord, I'm there, madam. We made retail exposition. We just